Applications and order for turns handover without mentioning. The rest, please wait. We'll take up. Applications and order for turns handover without mentioning. Order for turns.
Application. First appeal আছে application. Application ही হবে.
What is that? Why are you mentioning hearing matter, sir? Why are you mentioning hearing matter?
It's not only an appeal.
Pardon? We told you specifically application and order for turn without mentioning handover. Yes, please, from that side.
Well, this order 41, earlier occasion, this second appeal was admitted without framing any question of law. And the division
So
bench,
that has to be done now before the hearing bench.
single bench or division bench, this is the problem.
If it has been admitted, division bench is
without framing any question.
but division bench is functus officio. We cannot. Even if it has not been framed, you have to go before the learned single judge. Yes, because section 100 provides you read with order for two and gives you that leave to go before the single judge. Single judge can frame questions. Yes, yes, Mr. Bera.
Minor mistakes in their judgment related the appearance to be mentioned. Minor mistakes in the judgment for correction.
Oh, correction. For correction.
For correction. There is slight mistake with regard to the deposit of money, that is required to be corrected.
Yes.
Lord, leave to file, my lord, an appeal. Lord, I have the certified copy, entire certified copy, but Lord, some are, my lord, handwritten. Lord, they are asking for type copy, my lord. It's certified copy, my lord. Kindly grants me leave, Lord, so that I can file.
Leave to file. Leave is granted to file. Yes.
Great.
My lord, but please furnish those typed copies later on.
Very well, I shall do.
At the time of hearing, at least, yes.
My lord, belated payment of my lord special messenger cost, my lord, I am praying for an order of revenue.
To be mentioned. Right to be mentioned.
Application for
Yes, yes.
I have my lord's kindly.
Yes, please.
Appeal, first appeal.
Possible hearing we are not adding right now.
Cancer patient, respondent is cancer patient, my lord, kindly take it.
Wait for some time. We cannot touch it. So what is the use of no use keeping in the list because we cannot touch the appeal.
Many occasions I went, sir.
Many occasions we could not decide matters. Yes.
Yes, my lord. Leave to file an appeal without the certified copy and to move it on urgent basis on tomorrow.
Without certified copy, appeal again, first appeal.
My lord, first miscellaneous appeal, I have come up against my lord refusal of my granting my lord ad interim order of injunction.
Why couldn't you obtain a certified copy?
My lord, it was passed in Saturday, my lord. My lord, the fact is, my lord, I have prayed for injunction of a notice.
Without certified copy, it will be not in form. We cannot give that.
I shall apply it tomorrow, my lord. In the meantime, if
it could have applied on Saturday itself.
My lord, Saturday, this harbor order was passed, my lord, in the afternoon, my lord, when the time.
So in the before the evening, you could have applied for certified copy.
No, my lord, they city civil code, my lord.
No such leave. No. That is
my lord, because my lord, the urgency is, my lord, the notice, my lord,
this appeal we cannot permit you to file without certified copy.
My lord, I shall furnish. I undertake to furnish the certified copy in the course of hearing, my lord. I undertake to file it. And my
very well, leave is granted.
And my
after likhedin, leave granted on undertaking to file certified copy as soon as available. Yes.
And my lord, one more indulgence in this matter, my lord. Kindly takes it up either tomorrow or day after tomorrow, my lord, because the urgency is.
Day after tomorrow, list in order 41.
Grateful, my lord.
Yes.
Lordship, may I permit to mention a matter for inclusion of the list under the heading hearing?
Yes.
Your Lordship, may I have Your Lordship's kind leave to mention a matter? Your Lordship, the contempt application is listed on 9th of May. And this the first appeal hasn't been heard yet, Your Lordship.
Contempt application will take up the contempt when it comes.
Your Lordship, the contempt is listed against the order, Your Lordship. The first
what
appeal,
are you wanting now?
Before Your Lordship is the first appeal.
First appeal hearing we are not adding now. Yes.
Your Lordship, on 12th of December, Your Lordship, to brought the trial court record, but asking the department, the record not yet.
Has the department given a report? Just inquire before the department what is the report. Ask them to give a report, then mention. Without a report, it's useless. Yes.
Under actually, Your Lordship, the executing court has passed an order for taking possession. Your Lordship, kindly takes up this matter tomorrow. Otherwise,
what is this matter? An application?
Second appeal. Mr. Mondal mentioned this matter.
Has it been admitted?
Pending for admission.
Hand over the slip. It's a list order for 21. It will appear tomorrow under the heading order for 21. Give a slip.
স্লিপ জমা করে দিই। আপনার কাছে জমা করলাম এই মাত্র।
So why are you mentioning it then? You have given the slip. Why are you mentioning again? Wasting time. Yes, call on the list. যা যা এখানে যা ফাইল আসবে নতুন সব দিয়ে দেবেন পরের দিন, যখনই ফাইল আসবে দিয়ে দেবেন, এটা স্ট্যান্ডার্ড। ইয়েস, কল অন দ্য লিস্ট।
My lord, and item number one, my lord had appeared on behalf of the
Why it has appeared? Since one of us within bracket Aman Nam had appeared for one of the parties while at the bar, comma, let the matter stand released from our list on personal ground with liberty to the parties to seek an assignment before a different bench.
I'm good.
Thank you.
Item number.
I had
12.
appeared.
Yes. sir.
Same order. Same order.
I am for the petitioner, my lord.
Why is it appearing as to be mentioned?
However, it is appearing as
Substitution
to be
application, my lord.
19 reference petition were disposed of by the trial
15.
court, reference court, and my lord, when appeal was preferred, this court passed a conditional order to deposit some cost towards admission of the condition of below section 5 and deposit the balance repeated amount. The moment they failed to deposit that amount, that's why your lordship, out of 19, in 16 appeals, those orders were passed. And subsequently, after 3 years, they approached your lordship for condonation of delay of depositing that amount. Your lordship had disposed of those 16 appeals by these orders. Dismissed the appeal.
Appeals have been dismissed.
16 appeals have been dismissed. out
So
of
this
19.
appeal, the appeal which is now before us,
These 3 remain separately. No order was passed on this.
if a substitution order is there, we cannot,
That's why at that time no order was passed. But
in the name of a dead person, let us allow the substitution then.
substitution allowed, then your lordship.
Substitution within time.
Yes, yes, yes.
If they allow substitution,
If they have not filed any, have you filed any? No. Why did you dismiss? Let us just check. Oh, condonation of delay. In this matter also, condonation was granted subject to cost.
no order was passed in these 3 appeals. That's the difficulty.
Regarding condonation application, is there any condonation application?
Yes, condonation application and 3 application is there. But since these 16 appeals have
Will-
already been dismissed,
This application substitution is within time.
Yes, yes. Within
So we'll
time.
allow this substitution and direct the other matter applications to appear in the list so that we can pass similar orders.
very
It- We'll direct all the applications to appear together because it is appearing to be mentioned today.
your lordship can dispose of the appeal in terms of these orders. The orders is already.
Yes, what do you say? We allow the substitution and dismiss the appeal.
Yes, yes.
Very well. Can 5 of 2025 is an application for substitution of the heirs and legal representatives of the respondent, namely Kartik Hazra alias Kartik Chandra Hazra. First up, since the application is in time and otherwise informed, comma, can 5 of 2025 is allowed, comma, thereby directing the heirs and legal representatives of the deceased respondent, comma, as mentioned in the cause title of the application, comma, to be substituted in place and stead of the said deceased as his heirs and legal representatives in the appeal. First up, the necessary consequential corrections shall be carried out by the learned advocate on record for the appellant during the course of the day.
Yes.
To the memorandum. Necessary correction to the memorandum. Next para, learned counsel appearing for the appellant points out that here no order was passed in connection with the section 5.
No order was.
So section 5 you have to take up first.
Yes, your lordship can dismiss on section 5, but
Why should you dismiss section 5 without hearing it? We may not dismiss it. In the other case, condonation had been allowed subject to payment of cost. That's why you had dismissed. They did not pay the cost. That order was not compliant. That's why dismissed.
Yeah, that's
On merits application, section 5 application was allowed in those cases.
why I am saying, 19 reference petition by analogous order.
Maybe, Mr. Bera, in those cases that situation was different. Their condonation application was allowed.
Yeah.
They subject to cost, they did not put in the cost. That's why dismissed. So going by that order, we should allow the condonation application subject to costs. So let us put the other applications in the list. the other pending applications be listed tomorrow under the appropriate heading. এটা ফেরত দিয়ে দেবো নাকি মিস্টার বেরাকে? মিস্টার বেরা, প্লেস দিস অন দ্য নেক্সট অফিস। কালকে বাকি অ্যাপ্লিকেশন গুলো সব যা যা পেন্ডিং আছে দিয়ে দেবেন লিস্ট।
Not, there cannot be any different result. That's the difficulty. I am.
Yes, their condonation was allowed. They failed to comply, that's why it was dismissed. We have to wait in this matter for them to fail.
That's the difficulty. But in these three appeals, these three appeals will be heard separate without being.
Has to be, because their section 5s are there. If you allow that, going by the previous application, section 5 should be allowed then. Protocol.
6, my lord, I appear for the appellant petitioner, my lord. This matter, my lord, earlier occasion, my lord, directed to serve notice upon the respondent, my lord. But through department, normal post, it not it was no track report was there. Thereafter, matter came up before the learned registrar Lojima on 6th of January, my lord, where learned registrar Lojima directed the appellant to deposit a special messenger speed post with acknowledgement. But that time I was not there. Subsequently, I came into picture in 25th of March. Upon considering the record, my lord, I found that that was not being complied. I immediately deposit that. The respondent is not yet appearing, my lord. I kindly direct the department to accept that cost and
Learned counsel for the appellant verbally submits, verbally prays for condonation of delay in depositing Tolobana with written up notice forms as per the direction of the registrar administration within bracket L and OM, comma, sitting in Lawazima jurisdiction, comma, on August 29, 2022. Full stop. Next para, since such costs have already been deposited by the appellant, comma, we condone the delay in depositing such costs and written up notice form and accept the same. Full stop. The office shall act accordingly on the basis that the said deposits are valid.
it was January 6th, my lord. 6/1/2025.
We have an order dated 6/1/2025 also.
Yes.
No, previous orders were also there.
Yeah, the last order is 6th January, my lord. 6th of January. I could get it from the server also.
January, you don't find anything.
If my lord, may I hand over?
January, you don't find anything. Rather, the direction. নোটিশ ইস্যু করে দিয়েছে বলছো তো। কালকে করে রিসিভ হয়ে গেছে। But the records have already arrived.
The records arrived. It's upon the notice upon the respondent, my lord. Record has been arrived, that is in now in form also. That defect has been cured. But respondent has not yet.
আচ্ছা, যেখানে বললাম August 29, 2022 as well as on January 6, 2025. Both dates you are directed.
Deeply.
Thank you.
Now it is in order.
Appeal এখনো defect cure করার জন্য
Now in order.
তো in order হলো records এ কিন্তু সার্ভিস এখনো হয়নি।
Service.
Ready for hearing হয় না। Otherwise, yes.
When my lord, I'm for the
Why is it appearing under the heading application?
My lord, this is my lord restoration application. Dismissed for default.
At the order for stage.
Yes, my lord.
With
This
a
is not
delay?
The affidavit of service.
With or without delay?
Without delay.
Within time?
Yes.
Yes.
My lord, only I'm appearing for respondent numbers.
Served on all? You have served on all?
Yes, my lord. I am appearing for not all, but one.
No, but they have all been all have been served. You are for one.
1A, 1B, 2A, B, C, D.
Very well. Despite service, comma, which is evident from the affidavit of service, which is filed today and kept on record, comma, only some of the respondents are represented in court today. Full stop. Upon a perusal of the averments made in the application, comma, we are satisfied that sufficient cause for the absence of the appellant on the relevant date has been made out. Full stop. Accordingly, can 1 of 2023 is allowed, thereby recalling the order dated June 8, 2023, passed in SAT 3 of 2022 and restoring the said appeal to its original file and number. Full stop. The appeal be listed under the heading Order 41 Rule 11 of the Code of Civil Procedure tomorrow.
If it can be managed on 19th,
That is a condition for allowing the expression.
day after tomorrow.
No, tonight. You have to prepare tonight.
One more submission since my lord is taking up the order 41. My lord, we have also an my lord appeal arising out of same impugned judgment and decree. My lord, that order 41 is also pending. May that be tacked together.
We will hand over the slip. Tell tomorrow na kore, your prayer is allowed. Then be listed on listed tomorrow na kore, listed on May 13, 2025, along with write on a slip of paper. Along with SAT number যেটা উনি স্লিপে লিখে দেন. What is the number? Tell us.
SAT 121 of 2021.
SAT 121 of 2020. Both will appear together on 13th of May. Next.
Grateful.
Thanks. Order 41 যাবে.
Nothing for the respondent.
Respondent. None appears for the appellant at the time of call. Respondent's application.
There are applications by the applicants.
None appears for the appellant at the time of call, although the respondent numbers 1 and 4 are represented through counsel. First up, it transpires from the records that none appeared for the appellant on April 29, 2025. First up, however, comma, an adjournment had been sought on April 30, 2025 by counsel. First up, next para, as a last chance to the appellant to move the matter.
My lord, I am sorry for that, Danny. I am led by Mr. Adip Chandrakar. He is coming short passover. I am pretty sure he is coming.
Comma, full stop. Let the matter stand as a last chance to the appellant to appear in the matter, comma, let the matter be listed tomorrow. Next. না নাম দেবে না দেবে না
Advocate on record.
No,
I am the advocate.
we have already passed an order. Yes.
Lordship, in this matter, and for this appellant, I'm praying for this accommodation for 1 week, Lordship.
You are praying for? Why?
Accommodation. Lordship, affidavit of service has not completed yet.
Why not completed? When did you direct you? When were you directed to serve?
Lordship, this is the first time this matter has been
If
asked.
it comes up for the first time, no question of affidavit of service. Move the matter. Move the matter. We'll dismiss your default otherwise. What is the matter about?
I'm ready for this matter.
Yes. What is the appeal against?
Lordship, I'm challenging.
You have challenged a preliminary decree.
Lordship.
We'll direct you to serve copy and pass the usual order. The present appeal arises out of a preliminary decree of partition. Full stop. Next para. The petitioner shall serve a copy of the application on the respondent, indicating that the matter shall be listed in the monthly list of June 2025 for hearing. Full stop. An affidavit of service shall be filed by the appellant on the said date, on the returnable date. Full stop. The trial court shall continue with the final degree proceedings, but shall not draw up any final decree without the prior leave of this court till disposal of the application. So whatever order you could get, you have got. What is your name?
Sushmita Shenapati.
Sushmita
Shenapati.
Shenapati. How long are you practicing?
2 years.
2 years. Who is leading you?
Advocate Ashit Kumar De.
তাহলে ওটা মিস সুস্মিতা সেনাপতি, প্রথম লাইনটা করে দিন। মিস সুস্মিতা সেনাপতি appearing for the appellant along with a senior, নামটা যেটা দেবেন উনি, submits that the present appeal arises out of a preliminary degree of partition. Full stop, tarpor judge. Right. Yes.
Gopal Chandra Ghosh, applying for the peace.
You're there.
Last occasion, I think, last occasion I was not here, my lord, but I came
Sir,
to know.
Gopal Chandra Ghosh is appealing for the other side.
No, petitioner, my lord.
With you. Yes, yes. What is the matter?
Last occasion, you lord, see direct hard copy.
Have you served copy?
Already.
Good service, Mr. Banerjee.
Yes, my lord.
Did you grant any interim order?
Yes, my lord, granted.
What is the appeal against?
Just a minute.
Mr. Ghosh has studied, you have not studied, that's right.
My lord,
you're taking a risk. If Mr. Ghosh has also not studied, then?
just a minute.
And in the second paragraph, you have
Ural Hevanama,
quoted the prophet.
Ural Hevanama in past, already past, gifted in my favor, my lord, but he responded, my lord. He was not present at that time, my lord. He responded, my lord, due to taking advantage, my lord.
What is the suit for?
Suit for injunction, my lord.
No, no. Declaration that a deed of gift is void ab initio. Why was the suit dismissed? Your suit?
Yes, ma'am.
Why dismissed, Mr. Banerjee? On what ground?
Oral gift has been oral Hevanama in favor of my
How did you prove the oral Hevanama? By witnesses?
By?
Witnesses proved the oral Hevanama.
At that time, he was in Gujarat, my lord, on that taking advantage, my lord. He got the property, my lord, through my lord, gift, my lord. They responded, private responded.
Privacy case আছে পরে একটু কনভিক্ট করে গেছে রিভোক করেছে কিনা এসব affidavit of service filed today be kept on record. Full stop. It transpires therefrom that good service has been, no, one of them has been served.
No, my lord, only one, my lord. You confirm, my lord, you lost the country.
Oh, there is only one. Achha. That it transpires that the respondent has been duly served. Full stop. Next para. Upon hearing learned counsel for the appellant stroke petitioner, comma, we find that a strong prima facie case for hearing of the appeal on merits have been made out. Full stop. Next para. Accordingly, can 1 of 2024 is allowed, comma, thereby granting injunction restraining the respondent from changing the nature and character of the suit property and or from selling, transferring, encumbering and or alienating the suit property in favor of third parties in any manner till disposal of the appeal. Full stop. Next para. The appellant shall put in due requisites, comma, if not already put in, comma, for service of notice of appeal on the
But that
respondent.
has been already served.
Notice has been served.
Yes, my lord.
No service report is there. Acha, thale, other directions were passed regarding paper books.
No, paper.
Then we'll direct that. তাহলে প্রথম লাইনটা মানে এটা ছেড়ে দিন ওটা দরকার নেই. Since requisites have already put in for service of notice on the sole respondent, comma, we direct that the trial court records be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Right.
Lordship, I appear for the affidavits in this matter.
Applicant. For the first time?
Lordship, this has been admitted and Lordship was not minded to dispose of the application on the last occasion on the prayer of the respondent. This is, I'm the defendants in a suit for specific performance of contract.
Yes.
Lordship, a temporary injunction was granted against me, whereas there were documents on record to show that the plaintiff had neither shown his, prima facie shown his readiness or willingness. Lordship, I had
Oh, yes, yes.
Yes, 21st April's order, Lordship, 21st
yes,
April
yes.
2025. Since an accommodation was paid on that day, Lordships have stayed the order till the disposal of this application, Can 1, because they had paid for an accommodation on that day.
We'll extend the state till disposal of the
Lordship, I'm great.
none appears for the respondent as at the time of call. Push up next para. The bone of contention in the present matter is whether the appellant, the respondent, the plaintiff stroke respondent was entitled to the impugned order of injunction in view of the respondent having failed to prove, even prima facie, the respondent's readiness and willingness for performing his part of the contract by paying the consideration amount. Full stop. We find from our order dated April 21, 2025, that the appellant had specifically reiterated that appellants had specifically reiterated that they were ready and willing to execute a sale deed pursuant to the agreement in question in favor of the plaintiff stroke respondent, subject to the balance consideration amount being paid by the respondent. Push up. However, the upon being specifically asked by the court, the respondent had sought an adjournment on the said deed. Full stop. Next para. Thus, we find from the developments in the present matter that the respondent is prima facie not ready and willing to perform his part of the contract, as such disentitling the respondent to get an order of injunction, since no prima facie case on specific performance has been made out. Push up. Accordingly, Can 1 of 2024 is allowed, thereby granting stay of operation of the impugned order till disposal of the appeal. Push up. Next para. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal is dispensed with. Push up. Do you have all the papers?
Lordship,
Or should we call for the rep?
No, I do have.
Since learned counsel for the appellant submits that the appellants are posted with the relevant papers, we dispense with the calling for the trial court records. First up, the appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks.
6 weeks.
Within 6 weeks from date. First up, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm deeply obliged.
Thank you.
Well, my lord, I appear on behalf of the appellant petitioner, my lord.
Yes.
I am appearing for the respondent number 1 and
The suit for
2
party,
and 3. I'm sorry.
suit for,
When? The others have been served, Mr. No direction.
No, there's no direction.
You
There-
lost the caveat.
Caveat, I will serve.
I think respondent number 1 is already dead.
Dead.
I have no instruction, my lord.
Yes, and she
Then you
had-
have to inform Mr. Mukherjee.
no,
Proper.
she expired during the pendency of the suit, and her name has been expunged.
Is it?
ডিক্রিতে তো নেই ডিক্রিতে থাকতে হবে তো।
That's my instruction, because the preliminary decree has been drawn up considering her as deceased. Rashid kindly comes to,
But a name appears in the decree.
Yes.
yes, but
Which page? Which page?
but Lordship
Then-
kindly comes to the judgment, page 36 of 39. I have got the computerized copy.
Yes, yes. He's right. Last paragraph.
Total
Distribution among
Mira
legal
died-
heirs of Miradas since deceased.
তাই না, যেখানে ওই এটা লিখলো, শেয়ারটা লিখলো।
আচ্ছা, application করুন। Right.
Miradas's date of death is also there.
Yes, and
Her heirs are already on record because
already on record.
so we'll direct you to expunge and send back the decree for correction. But what about this condonation application?
The 87 days delay, my lord,
What is the ground?
kindly comes to 6 onwards, my lord.
My lord, my learned friend's
5 onwards.
my learned friend's friend has gone for a 90 days hiatus.
Who?
5, my lord. The learned advocate in the court was out of station, my lord. Subsequently, my lord, this was
Out of station for how long?
Thereafter, my lord,
You have not given any date. This is not any explanation at all. Had gone out of station.
I was
Somebody else should have been looking after the matter. No. The span is not important, but the explanation is. This is no explanation at all.
In that event, may I file a supplementary affidavit?
What will you add there?
The details
And
of
the tickets and all.
Details, my lord. Because that was I asked them why was the delay. That was the reason he told me, my lord.
And you wrote that blindly, Mr.
Well,
Bhattacharya.
I
Should have
have
been more cautious.
It
It was filed for some other court.
No.
2024.
Learned counsel for the respondent numbers 2 and 3 stroke caveators rightly points out that the respondent number 1, Srimati Meera Das, has been recorded in the judgment of the trial court to have met her demise during pendency of the suit on January 15, 2022. Full stop. Next para. In fact, comma, it appears from the said judgment that the heirs and legal representatives of Meera Das are already on record and were also on record before the trial court, comma, among whom shares have been distributed by the impugned judgment. Full stop. Next para. Hence, comma, we direct the learned advocate on record for the appellants to delete the name of Srimati Meera Das from the array of parties in the appeal, comma, and to carry out the necessary consequential amendments to the cause titles of the memorandum of appeal and all the connected applications during the course of the day. Which of next para. However, comma, prior to sending the trial court's decree, comma, where the name of the said deceased is appearing as one of the parties, comma, for correction, comma, we intend to pass orders on the pending applications. Full stop. Next para. Accordingly, Can 1 of 2025 is taken up for hearing. Full stop. We find from the application that sufficient explanation for the delay has not been made out, and it has only been narrated in paragraph number 5 of the same that the learned advocate dealing with the case on behalf of the appellant was out of station. Full stop. However, comma, considering the delay of about 87 days, comma, we are not satisfied of the explanation. Full stop. At this juncture, comma, learned counsel for the appellants seeks leave to file a supplementary affidavit to furnish further explanation and particulars in that regard. Full stop. For the ends of justice, comma, we grant such leave. Full stop. The appellant shall file the supplementary affidavit on the returnable date with an advance copy to the learned advocate for the appearing respondents. Full stop. Next para. We are not even directing service now because we have to be satisfied first. The application shall next be listed on May 13, 2025. 13.
Section 5 মুখস্থ করছো যেতে হবে না
পয়েন্ট আউট
আপনার সেদিনের জন্য বেড়াতে গেছে
মুখস্থ করছো শিখলাম আমি ঠিক আছে শিখলাম
না আপনি না বুকের লোয়ার কোর্ট অ্যাডভোকেট 27
শিখলাম
কিছু কোনো গচ্ছিত পার্টিকুলার দেবে আর অন্য কেউ অন্য কোনো কে রেখে যায়নি সব ম্যাটার তার মানে ডিসমিস করে দেবে Yes, sorry.
No, the appellant filed a suit for dissolution of marriage by passing a decree of divorce, my lord. I filed a expeditious hearing of this appeal.
Your suit has been dismissed. Since the present application is one for expeditious hearing of the appeal, comma, prior notice need not be served on the respondent.
My lord, I have already deposited written up
You have deposited
notice and Tolovana.
Very good. It is submitted by learned senior counsel appearing for the appellant that written up notice form and Tolovana have already been deposited Full stop. We accordingly dispose of can 1 of 2024 by directing the appellant to put in the special messenger costs for bringing the trial court records by such special messenger. Full stop. Upon such deposit being made, comma, the office shall ensure that the records are brought by special messenger. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Grateful, Lordship.
Thank you. No rest to cost. It will be called first.
My lord. My lord, I seek my lord's apology. My lord, I'm going to seek for adjournment.
Why?
Because my lord, the CAN one is an application for condonation of delays has not been service has not been complete. The CAN one is a
We
cross
directed
objection.
service.
And we have not, my lord has not directed service, my lord, but as it's an application for condonation of delay of the cross objection, my lord, which we have filed, my lord, this is a cross appeal. My lord, I was just seeking if my lord keeps the matter day after tomorrow, I shall come back after servicing.
The prayer of the year for the respondents. On the prayer of the respondents stroke cross objectors, comma, the matter is adjourned till May 7, 2025. First of, in the meantime, comma, a copy of the application as well as the memorandum of cross objection shall be served on the learned advocate for the appellants.
My lord, I shall, my lord. Grateful lordship.
Mr. Mukherjee, you're appearing for the appellant in this? Yes.
Item number 50.
My lord. Well, in this matter, my lord, your lordship direct me to serve the learned trial court learned advocate and the non-appearance of the respondents. My lord, as regard the learned advocate of my lord, he is also died. That's why I'm not contacted the learned advocate. And the others, my lord, the present address of the someone appear. If your lordship direct them to accept all of them.
How can you direct them if they don't have instruction?
Again, you will lordship direct me to serve by rest post, by speed post.
But you have to furnish the correct addresses now.
My lord, correct address, this is the plaint. As per plaint, I correct address subject. As they can present address, my lord, I find out. And if the landed court help me to current address, supply the current address, then I serve the speed post.
No.
I'll see the order, your lordship order.
Where is the fresh affidavit of service? File that.
My lord.
We directed you to serve again.
Again, my lord.
And to file an affidavit of service. Where is that affidavit?
That is not complied with. My lord, we go to the trial court advocate. My trial court.
We have to write that in the affidavit of service that we tried to serve but could not be served.
Then your lordship
directed you upon effecting corrections.
My lord.
The appellant shall serve fresh copies of the application on the unserved respondents at their current addresses and file a fresh affidavit of service on the next returnable
Then
date.
your lordship will give me another chance. Another chance.
In the event,
my lord,
current addresses could not be traced out,
then the learned
it will be
advocate.
served on the learned advocate. You have to
My
file
learned
an
advocate-
affidavit of service
My lord.
saying that respondent's advocate has also died.
My lord.
Learned counsel appearing for the appellant submits that despite despite all efforts, the appellants could not find out the current addresses of the unserved respondents. It is submitted that the service was sought to be effected previously at the address of the respondents which appeared in the plaint. They were the plaintiffs.
My lord.
Of the plaint of the respondents. Next para. In the order dated April 8, 2025, we had directed that in the alternative, the learned advocate for the respondents in the court below was to be served. However, it is submitted today that the said learned advocate has also died in the meantime. The appellant shall file a proper affidavit of service indicating such developments on May 7, 2025, when the application shall next be listed under the same heading. Day after tomorrow, affirm an affidavit of service, say that. But whoever tried to serve, he has to affirm the affidavit. If the client tried to serve, Then the client has to.
And others are appear, my lord.
Whoever is appearing will take up the application. Yes. You are co-plaintiffs with them.
My lord.
Then we'll deem it to be good service on the
My
lord. If you fought together in the court below, if some of you are only appearing here, we'll deem it to be good service. They are deliberately avoiding the others who are not appearing. Yes.
But here, my lord, defect I have found, my lord, that my lord, that decree, but decree is with the my lord, judgment, and the date has also been put in. If you like, see once the report of the
Certified copy of the impugned decree.
but, decree, my lord, what we found, my lord, we have filed, and the decree, my lord, you lordship know the date of the judgment or 20 rule 9, my lord.
No, no.
Date was there, subject to correction, my lord.
Yeah, but report on this part will be made possible after reflection of the relevant dates of certified copy of the impugned. Bullshit. Appeal was filed within time, otherwise.
There is a condonation of delay. What happened? Matrimonial suit has been filed by the wife, knowing fully well I am not residing there. In spite of the same, my lord, my
Appearing for the first time. We find from the materials before us that there is no defect otherwise than the appeal being filed beyond the limitation period. Full stop. Since the appellant has filed an application for condonation of delay, comma, we take up the same. Full stop. The appellant shall serve a copy of the application on the respondent, indicating that the application shall be listed next on May 19, 2025, when an affidavit of service to that effect shall be filed by the appellant. The appellant shall serve copies of can 1 of 2025 along with can 2 of 2025 on the respondent.
Rather, defect should be appeal is out of time.
Yes. No, that is what has been said. That could not be said before the. We'll now ourselves forget the law.
Well, there has been a in 14. I am the appellant. I thought it is
passed an order.
Yes.
Yes. Next.
Your lordship has directed some copy upon us, a cross appeal.
So then it's all right.
Yes. But our name should be recorded.
No, did we record something that you are not appearing? We don't know. We have to see the order for that.
একটু kindly দেখুন I'm sorry
14 এ দেখুন কিছু আছে দেখো কি আছে 14 এর অর্ডারটা একবার পড়ে দাও somebody else has taken we cannot incorporate your name now sorry you are not there because it
no I was there I thought that I am in
so now we cannot somebody else has taken the order next
okay well I'm extremely sorry
no, it's fine yes
Lord, I am appearing for the appellant. On the last occasion, I was directed to.
You did not file the Talabana and notice of written up notice of form. That is the office report. Most respectfully submitted that Talabana of ₹4 along with written up notice forms has not been filed by an advocate.
Today, I will.
What is the application?
Lord, application on the last occasion, I was directed to serve a phrase as because they were not appearing even upon the service. I have served upon them a phrase, but in the meantime, appellant himself has died.
Appellant has died.
Appellant has died.
File a proper application.
Yes, I have made the substitution petition, and his son has come to the court. I shall affirm it today and file with my lord if
give the number to our officer. Today you can give the number later on.
Yes, my lord.
Very well. Learned counsel for the appellant submits that in the meantime, comma, the appellant has met his demise. Full stop. It is further submitted that appropriate steps in that regard are being taken for filing a substitution application. Full stop. Liberty is granted to the learned advocate for the appellant to furnish the number of the said substitution application later in the day to our court officer for the purpose of the said application being listed along with the current applications on May 7, 2025. Day after tomorrow it will appear. Please give the number. উনি শুনে নিলেন তো অর্ডারটা
This is my application. I'm being led by Mr. Shudhashatya Banerjee, Your Lordship.
What is the matter about?
This is my stay application, Your Lordship.
Stay against?
Yes, against order, judgment and order dated December 3rd, 2024, ejectment suit. A decree has been passed, Your Lordship. I'm praying for stay of the decree, and execution proceedings has already been started, Your Lordship. An order has been passed on suppressing
What
one
is
point.
can 1 appropriate orders? Can 1 and 2? Can 2 is for stay. Can 1 is
Yes, can 1 is for order 41, rule 27, Your Lordship.
that we'll deal with later.
Yes, yes.
Very well. So, but stay, we'll direct copy to be served out of 27 also. Stay application eviction decree on the ground that you are a what tenant?
Tenant, Your Lordship.
On what ground has it been granted?
Since we failed to pay for consecutive 3 months.
Default.
Default.
Only default.
The only default. And we have challenged this on one particular point, Your Lordship, undervaluation. That it is a commercial dispute, and it has been stated, Your Lordship, it's a commercial dispute. It should have been gone to the commercial division. On that basis, we have challenged. I'm
For
praying.
the time being, we'll grant stay.
Yes, Your Lordship.
Unconditional, but we'll keep it open for them to ask for.
Grateful, Your Lordship. Also, one point I'll just indicate, Your Lordship, before the execution application has been suppressed, that the appeal proceedings is pending, Your Lordship. It has been suppressed. I don't have the order with me, Your
We'll
Lordship.
grant a stay of the
Grateful,
execution. Right. Can 1 of 2025 is an application, captioned as an application for appropriate order, but in effect in the nature of an application for production of additional evidence under Order 14 Rule 27 of the Code of Civil Procedure. Who's up next para? The said the said application shall be listed along with the appeal for hearing as and when the latter is ready for hearing. Full stop. Can 2 of 2025 is an application for stay of operation of the impugned eviction decree as well as the connected execution case. Full stop. Next para. Being prima facie satisfied of an arguable case having been made out, we grant stay of operation of the impugned judgment and decree dated December 3, 2024, passed by the learned civil judge, senior division, second court at Alipur in ejectment suit number 12 of 2019, as well as stay of all further proceedings of the connected ejectment execution case, if levied, till disposal of the application. Full stop. Next para. The petitioner shall serve copies of both the applications on the respondents, indicating that can 2 of 2025 shall be listed for hearing on May 19, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Next para. Liberty, May 19 করবে না ওটা June 16 করে June 16. The respondents shall file their affidavits in opposition within May 23, 2025. Full stop. Reply, if any, shall be filed within June 13, 2025 in respect of both the applications. So you will serve copy of both the applications. Order 1427 will appear along with the hearing, but they'll file affidavits in the meantime.
Yes.
Affidavit directions remain the same. And this stay will appear on whatever date you have fixed, June 16th.
Grateful, Lordship.
Mr. Banerjee is in court, in the court precincts. Then give his name also. He has been designated now.
No.
Oh, sorry. Next.
I am for the appellant also. There is a defect is showing, but
What is the defect?
I not gone through the record also.
Not gone through the defects. You should have gone. You are moving an order for
It's
2011
the
matter.
first time it's happened.
First time your appeal, you don't know the defect. You mentioned it.
Lordship.
So why do you say first time?
No.
When you mention a matter, you have to check up whether there are defects or not. You have to point out to the court, not for the court to look into it. Certified copy প্রথমে ফাইল করি পরে ফাইল করি
And they are previous file.
ওটাই defect. Yes, we'll hear the matter.
Degree of the trial court.
We'll hear the matter. What is the matter?
The fact of the case is that Lordship, it is a plaintiff, decree holder, respondent, and appellant is before Lordship. The plaintiff filed a suit for declaration and injunction.
Plaintiff decree holder means it's a reversal judgment.
Reversal judgment.
Acha. You filed an eviction suit.
No, it's a declaration and eviction.
Declaration that
declaration that I am the owner of the plot.
Yes.
And eviction of the unauthorized occupant.
Fair. So trial court decreed.
Trial court
Why was it reversed by the appellate court?
Initially suit was proceeded expertly. It is a 2002 3 suit. When and the plaintiff had proceeded with this case, filed his examination in chief and tendered their documents and they are marked exhibits. Immediately thereafter, defendant come into the enter their appearance. The suit proceeded against come to the WS stage.
Pardon? Against? Take the microphone a bit closer to you.
After the evidence have been tendered by the plaintiff and documents are exhibited, the defendant entered their appearance in the suit. And the expertise stage was vacated.
Give us half a second. Mr. Banerjee, in the previous matter, we forgot to add one line. We'll keep the question of occupation charges open. We indicated to her, but did not put it in our order. 18, that was 18. 18 একটা line add করে দাও. The question of imposition of occupation charges as a condition for grant of condition for extension of stay shall be condition for grant of stay shall be open for being argued at the time of final hearing of the application. We are adding that. We indicated to her but forgot to do.
Now my appearance is
He's justified. He's justified.
Very good.
Yes, yes. Please continue. From where you stopped.
Yes, Lordship. Then defendant entered their appearance.
Then what happened?
Then the petition, they filed the WS, the issues are framed, and plaintiff again filed a fresh affidavit in chief. And at the time of tendering the documents,
Your previous affidavit was affidavit of evidence was expunged.
No.
Why
not,
fresh?
Not officially, but the trial
that was permitted. Could not have been.
Could not have
unless
but,
Order 18 Rule 17 was.
But the lawyer.
Anyway, so what happened then?
Proceeded with filed the fresh chief.
What is your ground in the appeal? Come to the ground.
Said that they tendered.
Why was it reversed by the appellate court?
They have tendered some documents at the time of second chief, but they failed to re-exhibit the others documents in the evidence. And considering all the
there is a question of re-exhibiting. They did not exhibit for the first time.
It was exhibited for first time, and the
defendant's documents were exhibited.
Yeah, initially exhibited at the
Why
time
should they re-exhibit? Once it's exhibited, it's a part of the record.
It's a part of the record.
Yes.
And considering all the records, all the documents, the trial court has passed the decree in favor of the plaintiff. The defendant.
So why was it reversed? That is our question.
Only on the ground that at the time of filing the second chief, the documents were not exhibited, and as it was not exhibited, the trial court should not have been looked into that document. This was the
it was already exhibited once.
Once it is already
was that portion of that finding of the appellate court?
Let's come to the page 1, point 1 of the trial court order, the appellate court order.
No, the appellate court held that the appellant, that means the defendant, had a good title.
Subsequently, it was held. Though it is fair.
That was the ground.
That was a ground, but also it is taken a ground that the documents not exhibited in the second chief is not taken into considerations. And that's the reason the plaintiff failed the
irrespective of your second chief, if the defendants have proved their title, then an eviction suit should automatically be dismissed.
Lordship, but the trial court holds that the documents has been relied upon. That document has not exhibited by the the prime defendant. The other defendant come with the title document. The person has deposed that he doesn't know what is the suit for, a deed for. He doesn't know who has presented deed, and that document has been exhibited on the instance of the other witnesses. The only point is that whether that documents has been treated as an exhibit document or not. Point number 3, Your Lordship, in the internal page 8 of the appellate court judgment.
Saifuddin Mondal is whose predecessor? Your or there? There?
No, plaintiffs. And one exhibit has been negated on the ground that it was not initialed by the trial court at the time of exhibiting that document.
Who negated? Trial court.
Trial court.
Where is that negation?
Trial court has stamped.
Where in the trial court? Which page?
No, it's appellate court holds that.
ট্রায়াল কোর্ট গুলো শুধু আরওআর এর এসব দিয়েছে, সিএসআরওআর এসব দিয়েছে, কিন্তু অ্যাপিল কোর্টে দেখছি এক্সিবিট এ পার্টটা
The second exhibit.
First exhibit is the patta. B is original rent receipts.
That was marked exhibited in the second exhibit. Appeal court negated the documents exhibited in the first.
What was exhibit 4? Deed of gift. Exhibit 4.
Deed, give deed of the plaintiff.
এক্সিবিট 4টা শুধু ইনগ্রাউন্ডে ইয়ে করে দিবেন, জজের সিগনেচার তো এক্সিবিট হিসেবে মার্ক হয়েছিল 4, এটাই বলছে মার্ক হয়েছিল, কিন্তু ও বলছে at the time of experience only deed dated 70 was exhibited when the matter came out as participated. এটা মার্ক হয়েছিল বলছে, কিন্তু সিগনেচার on the said deed by the learned trial court and no signature in the exhibit list. যদি এক্সিবিট হিসেবে মার্ক হয় আদারওয়াইজ তবে তো ওখানে তো টেকনিক্যাল হয়ে যাচ্ছে, এই গ্রাউন্ডে শুধু অ্যাসেট করে দিচ্ছে ফেরত দিই মানে দেখো জাস্টিফাইড ইন ডিসকার্ডিং এক্সিবিট মার্ক যদি বুঝে এক্সিবিট হচ্ছে এক্সিবিট নম্বর, you are admitting only on that ground whether exhibit 4 could be discarded by the appellate.
And the other points is lordship with the
What
whether
other
the
points?
earlier exhibited documents should be taken into record or not.
There is no finding of the appellate court on that.
Lordship, the subsequent all the pleadings, all the other exhibits has been negated by the appellate court. That is the why the plaintiff fails to prove his case, because the title deeds has gone. Only the
Not
record
negated.
settlement record.
Others have not been looked into probably at all. Appellate court does not look into the other.
That is the reason that it was not exhibited in the second time. But it should have. It has once it is exhibited as the part of the court record.
No, once it is exhibited, it is a good exhibit.
Lordship.
And the other documents were probably not even looked into by the appellate court. Very well. The present second appeal will be heard on the following substantial questions of law. Roman 1. Whether the first appellate court acted in a perverse manner in discarding Exhibit 4, despite the said document, being a deed dated May 4th, 1970, having been otherwise exhibited properly, on the technical ground that there was no signature of the learned trial judge on the deed as well as the exhibit list, without granting further opportunity to the plaintiff stroke appellant to take necessary steps, if so required, in that regard. Roman 2, whether the learned judge of the first appellate court substantially erred in law and in a perverse manner in reversing the judgment and decree of the trial court without adverting to the other exhibits apart from Exhibit 4, which included rent receipts, information slip of Khatiyan number 517/2, as well as the settlement record, while full stop.
And another deed was there, Lordship.
No other deed is a part of it.
It was in the
Including you have said, so it includes.
Lordship, you will find in
What
the
is
decree of
the what is the application?
The application for injunction, Lordship, not to create any third-party interest.
Very well. In view of the appeal having been admitted on the above substantial question of law, we find sufficient prima facie case having been made out for grant of injunction. Full stop. Accordingly, the respondents. Respondent numbers. Respondent 3, he was a regular defendant. Why pro forma respondent?
No, he was in the proportion of the appeal. It was made by the.
Then you have sought for injunction against both?
Against all the respondents.
Very well. Shall remain restrained by an order of injunction from transferring, alienating, and or encumbering the suit property in favor of any third party, and or changing the nature and character of the same till disposal of the application. Full stop. The petitioner shall serve copies of the application on the respondents, indicating that the matter shall next be listed before the appropriate learned single judge having determination, subject to being mentioned by the parties, and shall file an affidavit of service before the said bench as and when the application next comes up for hearing. Till disposal. Yes.
My lord, I am for the my lord. Plaintiff appellant before your lords.
Lordship, I am applying for respondent number 3, 4, and 5.
My lord, suit for a decree declaring that the entry regarding the shares of pro forma dependents, pro forma dependents, my lord, in the RS record and LR record are erroneous, and that the plaintiff have the 16 anna share in the suit property and other efficacy.
Condonation application has been allowed.
My lord, allowed.
Allowed.
Yes, my lord.
Sorry, please continue.
My lord.
You sought for a declaration that the records,
the RS record and LR record are erroneous, and the plaintiff have the 16 anna share in the suit property and other efficacious reliefs.
you sought for a declaration of your title also.
My lord.
Then,
my lord,
you lost in
my
both
lord,
the courts.
You
lost in both the courts. What did the courts hold?
My lord, the suit was initially dismissed, and the defendant appeared. Defendant 1 and 2, that is the BLRO, they appeared, filed the written statement, and the pro forma defendant appeared, they filed written statement with counterclaim. My lord, the trial court, my lord, dismissed the suit as well as the counterclaim. Against that, two appeal papers, one by the plaintiff and one appeal by the, my lord, pro forma defendant.
What was the counterclaim?
My counterclaim that they are the, my lord, absolute owner in respect of the
That
suit
was also
property.
dismissed.
My lord,
That was also dismissed.
in the court below, my lord, trial court dismissed the counterclaim. Against that, pro forma defendant file one appeal,
And your
the plaintiff
suit dismissal also
filed.
another appeal. Yes.
In the appellate court below, my lord, the dismiss the appeal filed by the, my lord,
Them.
my lord, the plaintiff, and the allowed the counterclaim appeal in respect of counterclaim.
So you have
That
to
was allowed.
file appeals against both.
Both, my lord. The plaintiff filed one, my lord, the suit dismissed in both the courts below, and my lord.
So you have to file two appeals now.
My lord.
You have filed only one appeal.
No, 161 and 162.
Two appeals have been filed.
My lord.
2021 একসঙ্গে বোর্ডে দেখান তাহলে ঠিক দেখ 21 is defective আর ফাইলটাও দিন বোর্ডে দুটো দেখা what is the defect in the other appeal 162 it's being shown as defective. Delay that has been gone.
Condoned, my lord.
What is your ground?
My lord. My lord,
why was the suit dismissed?
My lord, the learned court below, my lord, the fact is that, my lord, of the plaintiff case, my lord, my lord, the CS, my lord, the one, Ohid Box Malik was the original owner. And my lord, in respect of 11th decimal Bastu land. And my lord, he died, leaving my lord, wife, Sujan Bibi, and 3 sons. And my Sujan Bibi died, my lord, and 2 sons died as bachelor. And the only one, Ali Ahmed Malik, only the surviving son became the absolute owner in respect of the, my lord, 11 decimal land, my lord. And the Ohid Box Malik, after his death, my lord, he became the absolute owner and he became the Korfa tenant as per the, my lord, Bengal Tenancy Act, my lord. And thereafter, my lord, his name was recorded in the CS record of rights. And my lord, thereafter,
your predecessor,
my lord, my predecessor, my lord. Thereafter, my lord, LR information obtained in the year 2011, my lord, obtained by the plaintiff, it came to light that, my lord, the finally published LR record, the name of the, my lord, pro forma defendant number 4 to 6 is recorded with the plaintiff. Then, my lord,
who are they? Your relatives?
No, my lord, no relatives.
Not relatives.
No, my lord.
Then,
in the RS record, my lord, the father of the pro forma dependent number 3, 6 and father of the pro forma dependent number 4 have been recorded along with the plaintiff, my lord. Neither the plaintiff nor his predecessor have ever transferred any portion of the suit property to anyone. Pro forma dependent have no right, title and interest over the suit property. The entries in the LR record and RS record are erroneous. Even after receipt of the, my lord, advocate's notice under section 80 of the Code of Civil Procedure, my lord, the defendant, that is my lord, BLRO, my lord, did not correct the erroneous entries in the RS record. Therefore, my lord, suit arose.
why was it dismissed by the trial court?
Because, my lord, the suit has been filed in the, my lord, in the name of my dead person, my lord. My lord, it was not knowledge, my lord, of the, my lord, plaintiff, my lord.
Suit was filed in the name of a dead person. It is a bad suit. Trial court was right.
But, my lord, it was not knowledge.
Your
my lord,
knowledge is immaterial. No degree can be passed in the name
one of the defendants, my lord, one of the defendants. This is one ground, my lord. And my lord, kindly
see the appeal court affirmed that.
That was affirmed by the appellate court below, my lord.
Your prayer. What was the nature of your prayer in the plaint? Let us see your plaint prayer.
My lord, in my lord, 161, my lord, appeal 161, my lord, stay order, my lord, plaint, page 15, my lord, annexer A.
What is the finding of the trial court? Let us see the finding of the trial court, my lord.
Lordship, may I interrupt?
You don't have a right of hearing in the order for lordship. Take your seat. Represent.
My lord, I am placing my lord. This is a suit, my lord. This is my lord. Judgment of the trial court, my lord.
Which page?
My internal
Which page of the trial court judgment?
Internal page 2.
Why are you starting from 2?
My lord, the as many as my lord 10 issues have been, my lord, framed in respect of suit, and my lord 3 issues in respect of my lord counterclaim. That has been, my lord, the exhibited document, internal page 7, my lord. That has been, my lord, filed on behalf of the, my lord, plaintiffs. That is under internal page 7.
What is the finding that it was filed in the name of a dead person?
My lord.
Number 12. How did the appeal court deal with it?
My lord, the appeal court.
Affirm that.
Yes, my lord.
টোটাল সুটটাই নালিটি কিন্তু একজনের মধ্যে প্রত্যেকের কাছে কত জয়েন্ট পেনাল্ট গুলো জয়েন্ট ওনার গুলো ক্লেম করছিল প্রত্যেক ডিপেন্ডেন্ট এগেইনস্ট ইন্ডিপেন্ডেন্ট কজ অফ অ্যাকশন কারণ ওদের নাম প্রত্যেকের রেকর্ড হচ্ছে নালিটি এজ এ হোল এগেইনস্ট সেটা আর ওদের কাউন্টার ক্লেমটা ডিসমিস করেছে নন জয়েন্ট appeal court, what about their counterclaim? How was it allowed by the appellate court?
My lord, the held that, my lord, the
non-joiner, it was dismissed on the ground of non-joiner. How was it reversed? It was from the appellate court's judgment. Which portion?
This matter, not where was the vendor of misapprehension. Misjoiner কথাটা ভুল তারপর দেখুন and all the co-sharers have not
my lord, page 79, internal page, my lord, 6 of the appellate court.
Yes.
Decision with reason. Now we let us decide both the appeals.
Yes, on the dismissal of counterclaim, let us see.
Counterclaim. The learned trial court dismissed the counterclaim on pro forma defendant number 4 to 6 on 2 points. Firstly, they did not ask any request the plaintiff for amicable partition, and secondly, the non-joinder of their sister, Mohammad Hanif Malik, only legal heir son of the pro forma defendant number 3, Mehbooba Bibi, as necessary party, and thirdly, claim of pro forma defendants as exclusive owner of the suit property is redundant claim. In the matter of not asking for requesting the plaintiff for amicable partition of the suit property prior to the suit institution, it is well settled law that partition, since an incident to the co-ownership of the property, the right of partition cannot be raised once the parties are proved as co-owners. Division of the respective shares is a matter of right, and such right cannot be subjugated by any other proposition brought by any other co-sharers. As per evidence, both oral and documentary on record, both more particularly from the mouth of PW2 and PW3, this co-ownership of the parties in respect of the suit plot since admitted as well as proved before me. Demand of partition by the pro forma defendant number 4 to 6 to the plaintiff prior to the filing of the suit is not required under the law. Pre-suit demand of partition or not is no ground to refuse partition. So the findings of the learned court that since there is no pre-suit demand for partition of the suit plot to plaintiff, they cannot pray for partition. Is perverse and visceral. Now let us deal and discuss in respect of the matter of non-joinder of necessary party as observed by the learned trial court in the penultimate page of its judgment. It is observed by the court that PW1 Kaji Sadrul Alam, son of Kaji Hoijula, admitted in his cross-examination that the names of his sisters had not been recorded in the ROR, and so it is a case of non-joinder of necessary parties. But the learned court did not appreciate the DW1 clarified that position by this position by starting that since his father already transferred the property in favor of him and his brother, thus the name of their sisters were not recorded. As per CS ROR Exhibit 1 produced by the plaintiff side, the original owners of the suit plot number 399 were Pachkori Mollik and Sarikanesa Bibi. Pachkori Mollik was the owner of 4 annas equivalent to more or less 2 decimals, and Sarikanesa Bibi was the owner of 12 annas equivalent to more or less 9 decimal in the suit plot. Thereafter, said Sarikanesa Bibi transferred her 9 decibel in favor of said Kaji Mohammad Foizullah by Exhibit C, registered cell deed number 1296 of 1941, and who in turn transferred his purchase 9 decimal in the suit plot in favor of his son, namely Kaji Samsul Alam and Kaji Sardul Alam by Exhibit D, registered cell deed number 3857 of 1957. Both Exhibit C and Exhibit D are unchallenged documents by any contra documentary evidence, and therefore non-joinder of sisters, if any, of Kaji Samsul Alam and Kaji Sadrul Alam does not arise, and therefore the findings of the learned court dismissing the counterclaim as one of the grounds is without proper appreciation of oral and documentary evidence on record, and thus held perverse and baseless. It is the further observed.
Yes, we are admitting the appeals. Well, the present 2 appeals are connected, since they arise in connection with the same suit and the counterclaim filed in respect of the said suit respectively. First of next para, the appellants filed a suit for declaration of their exclusive title in the suit property, as well as for declaration that the entries in the records of rights were erroneous. First up, on the other hand, a counterclaim was filed by the defendant's respondents seeking partition of the suit property. First up, next para, while the learned trial judge dismissed both the suit within bracket primarily on the ground of nullity in view of defendant number 3 being dead at the inception, bracket closed, as well as the counterclaim within bracket on the ground of non-joinder of necessary parties, bracket closed, the learned judge of the first appellate court affirmed the dismissal of the suit, but reversed the dismissal of the counterclaim. Full stop. Next para. SAT 161 of 2023 has been preferred in respect of the first appellate court's judgment affirming the dismissal of the suit, whereas SAT 162 of 2023 has been preferred against the reversal of the dismissal of the counterclaim by the first appellate court. Push of next para. Upon hearing learned counsel for the appellants, we observe as follows, SAT 161 of 2023 shall be heard on the following substantial question of law, whether the learned judge of the first appellate court erred in law in holding the suit, whether the learned judges of both the courts below erred in law in holding that the suit was a nullity as a whole in view of defendant number 3 having died prior to the institution of the suit, without considering the question of severability of causes of action against the different defendants. Tarpore, SAT 162 of 2023 shall be heard on the following substantial questions of law. Roman 1, whether in view of the first appellate judge having erroneously held that the suit was a nullity, without considering the question of severability of causes of action, the decree passed by the first appellate court in the counterclaim is bad in law, having not reflected the shares of the plaintiffs. Roman 2, whether the learned judge of the first appellate court acted in a perverse manner in holding that the counterclaim was not bad for non-joinder of necessary parties, without adverting to the relevant materials and admission by DW1 to the extent that there were other sisters of the said defendant who were not impleaded as parties to the counterclaim. Push up next para. Any application?
My lord, application for stay, my lord.
Stay of dismissal of the suit, there cannot be any stay.
of
The
operation of the-
counterclaim part in can 2 has been filed in this 162 counterclaim. Yes, what
Common
this?
judgment, my lord.
Pardon?
This is common judgment, my lord.
But the decree is separate. Decree of dismissal of your suit cannot be stayed. There is no scope of stay of dismissal of a suit, but counterclaim, yes, what do you say?
In this matter, my lord, in both of this matter, the copies of the stay application has not yet been served. And this,
Who direct them to serve a copy? We lodged a caveat.
yes, yes, lordship.
Okay. No caveat has been lodged. That is a you have not lodged a caveat.
Pursuant to the direction, my lord, section 5 application we have served.
Lordship, section 5 application has already been disposed of, and this matter is being led by Mr. Iftekhar Munshi.
Maybe. Serve a copy of the stay
My
application.
lordship.
Can 2 of 2025 is an application for stay of operation of the impugned common judgment passed in both the appeals as well as the decree whereby the counterclaim of the respondents have been allowed. Push up. Accordingly, we grant stay of operation of the impugned judgment and decree to the extent decree of the first appellate court to the extent that the same allowed the counterclaim of the respondents till disposal of the application. First up, a copy of the you are appealing for all the respondents.
No, man. For 3, 4, and 5 for item number 20 and for item number 21 for
A copy of the application shall be served on the respondents in both the appeals, directly and stroke or through their learned advocates, if represented in this court. Full stop. An affidavit of service to that effect shall be filed before the learned single judge taking up the application next. Full stop. liberty to mention before the appropriate single judge having determination for inclusion of the applications in the list of the said bench. Serve copy of the application to him for whoever he is representing, serve him, and the others if applied. Next. Complicated as well. Yes. Aviator. Respondent number one is the main contesting respondent or what? Samkaji, others are not.
He is the plaintiff. He obtained he obtained the order of injunction, which is challenged by. He is the answer.
What are the facts?
Yes. The Rajobala Dei was the original owner in respect of the property in question. She died, leaving behind two legal heirs, Gitanjali and Pushpanjali. Both of them inherited 50% of undivided interest in respect of the property in question. No quarrel on that. The Pushpanjali, from whom the present plaintiff is claiming his right, Pushpanjali transfer.
Mr. Mukherjee, you did settle this memorandum. Parties had mentioned what is only appellant, why only appellant. You should have mentioned defendant appellant in the memorandum. And what is opposite party respondents? Should have been defendant number one, plaintiff respondent.
So 50% share, undivided share is being inherited by both Pushpanjali and Gitanjali. Now, my learned friend, my learned senior friend is representing the plaintiff. Plaintiff is claiming since through Pushpanjali. Pushpanjali transfer her 50% undivided share in favor of the present plaintiff, who is a stranger purchaser. He filed a suit saying that it is undivided interest, praying for partition and consequential prayer, injuncting me from transferring the property in question. So that is the ad interim order which was initially granted, that was made absolute, which is the order impugned before your lordship. The ad interim order was granted, page 25 of the stay application, your lordship will get that ad interim order. That the application for ad interim injunction is allowed, the defendant number one is restrained from alienating the co-schedule property, suit property till 5th of April 2021. Thereafter,
the prima facie possession has been held. They have entered possession. There is
I am the one of the married daughter of Rajobala Dei. So I am residing, but the co-sharer's possession, your lordship knows. Now the equitable relief. A person who is a stranger purchaser, who purchased 50% undivided share from one of my sister, and he is asking for partition and injuncting me from transferring.
Is there any bar?
I am coming that.
We'll continue.
Yes.
Yes.
My lord was of the view, my lord, whether there was any bar,
Yes,
my lord,
yes.
in by a
Because you
stranger
are a married
purchaser.
daughter. You are a married daughter.
I'm married daughter, my lord. My possession is there, my lord. I am residing at my matrimonial home. So, my lord,
Possession is notional possession. I mean,
no, my lord, my possession is there. My lord, I frequently, my lord, visit. My lord, it's not that, my lord, I am, my lord,
but it's no longer an undivided family dwelling house.
after, my lord, the purchase being made in favor of the present plaintiff. Now, plaintiff, my lord, purchased, my lord, the suit property and filed, my lord, just 1 month thereafter, that is 22nd of February 2021, the present suit seeking for partition and restraining me from transferring my share.
Wasn't there a bar to a stranger purchaser filing a partition suit unless one of the co-sharers seek it?
Yes, but my lord, in my written statement, I must be categorically before your lordship, my lord, that, my lord, that preemption, that preferential right has not been claimed. So that's why, my lord, I cannot, my lord, take that plea of the partition.
Section 44 is there otherwise.
Yes. Now, today, my lord,
but they are already in possession. They have been handed over possession.
That is, my lord, in respect of the 50%. They are seeking for partition in respect of the 50%.
So section 44 is not applicable in
No,
terms.
my lord, what happened, my lord, the coordinate bench of your lordship's court, when, my lord, this matter was being heard out, my lord, I have been given liberty to take out an, my lord, supplementary affidavit, because some of the important facts which was not there permitted to brought on record, my lord, by virtue of the supplementary affidavit that is on record before your lordship. Wherefrom it will be revealed that this third party stranger purchaser plaintiff before your lordship have already created, my lord, in respect of his share, he has already executed a agreement for sale in favor of some third party who has initiated a suit for specific performance of contract in respect of this, my lord, 50% share which has been purchased by the plaintiff from, my lord, Pushpanjali. My lord, kindly takes up now, my lord, the supplementary affidavit once.
What sort of injunction was granted? Let us see that first.
Oh, my lord, the
Impugn
ad interim, my lord, order, my lord, which I have shown before your lordship, restraining me from
You
transferring.
have not shown.
Oh, my lord, my lord, kindly takes up, my lord, it's my mistake.
Ad interim.
My lord, page 25 of the stay application, if your lordship
So
takes up.
just what is the date of the order?
My lord, the ad interim order is 8th of March 2021. This has been made absolute. So in the final order, which is impugned before your lordship will not get the operating portion. That's why page 25 of the stay application. Can one. My lord, kindly turns over. My lord, the admitted facts, I am not troubling. Page 26. That the application of ad interim injunction is allowed, the defendant number one is restrained from alienating the co-schedule property till 5th of April 2021.
Co-schedule is why co-schedule? There is only one schedule.
Yes. Your co-schedule, your lordship will get the entirety of the property.
So then what is the wrong in that injunction? I mean,
that's why I'm coming. This has been made absolute by the impugned order before your lordship. Now, if your lordship takes up the supplementary affidavit once. This was affirmed.
Regarding the supplementary affidavit, I have some objection because in that suit, till date, I have not got the summon. I do not know who has filed the suit. How they filed before your lordship.
they speak about a different suit.
I'm explaining.
Yes, that is different suit. And
have you filed any objection to this supplementary affidavit?
Yes, I'm filing this.
Forgot to file that before us.
Here, my lord.
Another copy there?
Not.
Giving copy now. Why didn't you give copies earlier?
My lord, if some mistake in my part, my lord, I have forgotten, my lord. My lord, the brief was misplaced. It is my fault, my lord. As your lordship desired to, because I have categorically denied. Till date, I have not got any summon. And whether the agreement made between us, the third party, I do not know. But that is the trial court decision, my lord. Whether the agreement
that will hear you, but yes, Mr. Mukherjee,
may I just show before your lordship what is the matter?
You will argue on the basis of this.
The non service of summons of that suit is neither here nor there. May I just take your lordship to the supplementary?
He is denying that agreement also.
That is, that is something to be decided in that suit. But today,
if you want to proceed on the basis of this,
may I come back?
My lord, subject.
Otherwise,
we are not forcing.
No, not subject to correction. If your lordship that interfere the agreement, then my lord, the court below will be prejudging because
the injunction application is prejudging. There is some amount of prejudging necessary.
And regarding the agreement,
we mitigate that by saying that it's tentative. There is some amount of prejudging in prima facie deciding a prima facie
No,
case.
regarding the agreement is question, the second suit.
The other suit will be prejudged. That is your point.
And my suit is suit for partition.
We are only on the possibilities. The anyway.
Yes.
So if you want to use an
I
very
need
well.
to-
Since learned counsel appearing for the appellant seeks to rely on a supplemented affidavit in support of his contentions, even in connection with the appeal at the stage of admission under Order 41 Rule 11 of the Code of Civil Procedure, and an affidavit in opposition thereto has been filed by the respondent number 1 today, with a copy being served on the learned advocate for the appellant here and now, comma, in order to enable the appellant to deal with the contentions in the affidavit in opposition, comma, liberty is given to the appellant to use a reply to the said written objection. Whose of such reply shall be filed within a week, shall be filed within a week from date, with an advance copy to the learned advocate for the respondent number 1. The matter shall next be listed under the same heading on May 14, 2025.
Great. Yes. Don't be
The
amiss.
affidavit in opposition filed to be kept on record.
Don't be amiss, my lord. It is my fault. I have lost.
No, why should you? Yes.
See, Lordship, in this matter, I am appearing for the Lordship.
Yes.
And for the Lordship, defendant, appellant, petitioner before your Lordship, where Lordship an injunction order was disposed of without considering my objection. When Lordship in the suit earlier occasion I have submitted before your Lordship that in the plaint there was Lordship only one plot, but in the injunction of application Lordship there was another plot was inserted. Lordship, kindly come to page 10 of my stay application Lordship.
The substitution has been allowed.
Substitution Lordship, last occasion Lordship allowed the application.
But I have also taken instruction, my lord, so far as the new plot which was incorporated in the my lord, this order 39 rule 1 and 2 application, my lord, was new to the proceedings. My lord. Was new to the
proceedings, to the suit.
Yes, in the suit.
So regarding that portion, we can vacate them.
My lord, the order was to maintain status quo in
Status quo.
respect of the suit property. So, my lord, kindly.
What was your
Suit for
suit
partition.
Suit for partition. But Lordship, kindly consider only one
Mr.
thing.
Shandal, he is very fair.
Yes, Lordship. Only one thing, Lordship, kindly consider page 15. Lordship, I am Lordship owner in respect of Lordship 2.5 decimals Lordship. I, without praying for any equity Lordship, as the Lordship construction has been raised Lordship up to the Linton level, at their knowledge Lordship. After Lordship, the construction was constructed up to the Linton level, they filed the injunction application. So Lordship,
this is against interim order.
No, Lordship, it was disposal. Yes, permanent.
Interim or final?
Final, Lordship.
Temporary.
Final, Lordship. Because objection was filed to this regard, Lordship, that the second plot which was inserted in the application, there is no existence, and I prayed for Lordship to construct without any equity in respect of my existence.
Only Linton level. Why should you be
Linton.
permitted to construct? Any other ground? You don't have a residence or something like that?
Because Lordship, I have cited the Lordship paragraph.
But you cannot take the best portion and make a construction over
No,
there.
Lordship, this is my
That is the
existing
nature of
portion.
this
Lordship, there was a kacha construction earlier occasion. Lordship, I want to make Lordship.
While he intends to, my lord, construct is a pukur par.
Kindly consider paragraph number line, Lordship.
Page 10,
There was
my
a
lord,
earlier
let him
construction
complete.
dwelling house, Lordship. And I have stated Lordship 3 নম্বর বিবাদীর পুত্র বিবাহ বধূমাতা সন্তানকে
Paragraph 10 of this stay application.
Stay application page 15, Lordship. Page 15. So there are subsection.
No, this is adjacent to the temporary structure where you are already residing.
Yes, Lordship. And
You have
Lordship,
not broken that down and making this construction. So that is
without
still
Lordship,
there.
Without exceeding my share. Without exceeding my share.
No, but you have chosen the portion. I mean, a particular portion, every co-sharer has right over every inch.
Yes, Lordship. But now, Lordship, kindly consider there is some judgment lordship of this where lordship the construction that plaintiff lordship allowed the defendant lordship to raise construction up to certain level.
Since when did you start construction? Where is that averment?
Much right.
Where do you say that in your objection?
In my objection, lordship, I have stated that it has been raised up to the Linton level.
Then
Up
might
to
have
the-
recently started construction.
No, lordship, before lordship institution of the suit.
That is being submitted from the bar. How do we know? There is no averment to that effect. That could have been one of the grounds. Your judgment, the judgments which you are citing, those are on that premise.
That lordship,
That they permitted you to make a construction, and then Linton level, up to Linton level construction takes a few days maybe.
now, lordship, what happened, lordship? The residence which has been constructed, lordship, kindly consider, lordship, if I undertake, lordship, that I will not pay for any equity. Because, lordship, from the LR record, lordship, and their document, lordship, it will be
That does not make the impugned order a bad order. Why should we do that in appeal? Why should you do that in appeal?
Because
in appeal, if you do that, that will be, we have to hold that there is some error in the order of the trial court. There is no error. Apart from that extra plot being.
extra plot has been inserted.
Extra plot he is admitting.
Because modification, lordship.
Where is the injunction application?
Injunction application, lordship, kindly come to lordship page 11. 11.
Page 10 is the plain schedule and page 13 is the injunction schedule.
Injunction schedule, lordship.
So this
1284?
1284 is extra.
Page 12 is the lordship the cause of action. So lordship,
We'll set aside, modify the order, setting aside only the portion regarding 1282, 84. But will not permit you to construct. We'll give our reasons. You want to cite your judgment side. So let us dispose of the appeal, Mr. Shanal.
as your lordship, but lordship kindly consider give us liberty to lordship take this point before the lordship learned court below to agitate this point, lordship, because if
Where? When will you take this point?
Yes, lordship, then we have to take an application for lordship 39(7), lordship.
39(7). How will that help you?
Because lordship, in my objection, I have already categorically stated, lordship, that at the time of receiving the summon, the construction has been raised up to the.
Achha.
To 2008-11 SCC page 1.
And his Mr. Ganguly, his son has been given in marriage. He requires an extra room. And is already only the roof of that one story. We can restrict him to that. Let the roof be completed.
It's not the case of the Malad, this appellant Malad, that Malad, he has no place to Malad. No.
He has stated in paragraph 9, নালিশি পুকুরের উত্তর পাড়ে 1 নম্বর বিবাদে একটি দোতলা মাটির ঘর রহিয়াছে, এই ঘরে তার পুত্র 3 নম্বর বিবাদী মানুষ সপরিবারে বসবাস করিয়া আসিতেছেন। 3 নম্বর বিবাদীর পুত্রের বিবাহ হয়, বধূমাতা বা সন্তানগণকে লইয়া সংসারে পোষ্য বৃদ্ধি পায়, মাটির ঘরের লাগাও একটি পাকা একতলা ঘর নির্মাণ করিয়াছেন, ছাদ এতক ঢালাই হয়নি। Only the roof has not been made.
Kindly see the extent of construction.
That is, lordship, the extent of construction. Because lordship, already the plaintiff have constructed this house. After he constructed the house, when lordship the defendant started.
We have also constructed. You have stated that also here.
No, that point. That point.
That photograph is not also a part. It was
Yes,
not.
no, that is not a part, lordship, of the record.
In the supplementary affidavit, you are relying on that. No.
No, supplementary affidavit has not been filed.
It may be your house also. How do you know?
I can lordship by filing supplementary.
Maybe our house also from another side. We don't know. It may be anybody's house. It's not a part of the record. Yes, which part para of this judgment? Let us come to this.
Lordship, kindly come to lordship.
Quick. Which part?
Which judgment?
Oh. Paragraph lordship 27 and 26 and
2008-11 SCC 1. Paragraph 20.
26 and 27, lordship. The
26 and 27
discussion has
come out separately. So
discussion has been.
Your stapler was not very good.
Discussion has been made in lordship paragraph number 21, 22 on.
21, 22. Let us see.
I am giving lordship another.
We have a stapler with us for people like you.
I am extremely lordship apologize lordship for that.
Either to seal the
Without-
mouth or the
So I did not check
to
this, Lordship.
staple
Kindly-
the judgments.
I am
In this case, the latter one. Yes. Para 20,
21, 22, Lordship.
Have you got an extra copy for him? Need not. It's a cited, reported judgment. Read it out. Read it out, Mr. Shana, so that he can also.
While considering an application for grant of injunction, the court will not only to take into consideration the basic element in relation thereto, the existence of a prima facie case, balance of convenience and irreparable loss and injury. It must also take into consideration the conduct of the parties. The grant of injunction is an equitable relief. A person who had kept quiet for a long time and allowed another to deal with the properties exclusively ordinarily would not be entitled to an order of injunction. The court will not interfere only because the property is a very valuable one. We are not, however, obvious of the fact that the grant or refusal of injunction has serious consequences depending upon the nature thereof. The court dealing with such matters must make all endeavors to protect the interest of the parties for the purpose of the application of mind on the part of the court is imperative. Contention raised by the parties must be determined objectively. Thereafter, Lordship, considering the fact, Lordship, that construction has been made, it has been decided, Lordship, to not to interfere with the properties 26 and 27 is the
Here
rate
it was a question of interference with an order of injunction granted by the trial.
by the trial court.
Here it's the reverse.
No, Lordship, they have, in that matter, Lordship, they have prayed for an injunction against the, Lordship, construction, Lordship, which has been raised.
Here, the court refused to interfere with an order which has already been
passed. In
Here you are asking us to reverse the order that has
No,
been
Lordship.
passed.
Then, Lordship, I have to, Lordship, read the some more
Yes,
more
just
paragraph,
see.
Lordship.
Para 27 says, we are of opinion that interest of justice will be subserved while allowing the respondents to carry out construction. The same is made subject to.
That has been, the fact, Lordship, has been discussed in paragraph number 9. Paragraph number 9 and, Lordship, 12.
They had spent 3 crores.
Yes.
How much have you spent? But Supreme Court 3 crores, 1/10 of that will do for it. Yes, Mr. Ganguly, what do you say? Two things. One is that you have already permitted them to construct a
kindly come to paragraph 2 of my plan. At page 8. But they are saying that they were constructing.
Yes, you permitted them to.
Malad, kindly see.
Para 2.
Yes.
Yes.
উল্লেখিত অবস্থা চলিতে থাকাকালীন ইংরেজি 2/4/2021 তারিখ হইতে বিবাদীগণ একযোগে নালিশি দাগের বাদীর আপোষ ব্যবস্থা মধ্যে দখলি ভূমির ওপর পাকা গৃহাদি নির্মাণ করিয়া পরিকল্পনা লইয়া তথায় গোড়াট কাটিতে শুরু করেন. So at that point of time, my lord, the property
was just starting.
Was started, my lord. বাদী খবর লইয়া নালিশী স্থানে উপস্থিত হইলে এবং 2 ও 3 নম্বর বিবাদীগণকে তাহার এই প্রকার কার্যাদির কারণ জিজ্ঞেস করিলে বিবাদীগণ বলে যে তফসিল ভূমির দাগের ভূমি যেহেতু কোনো মাপজোক করিয়া বিভাগ বন্টনা হয় না, সুতরাং তিনি যে কোনো স্থানে কনস্ট্রাকশন করিতে পারে। বয়স্ক বাদীর কোনো কিছু করার নাই। বাদী সে সময় 2-3 নম্বর বিবাদীগণকে আপোষ তফসিলুক্ত দাগের সম্পত্তি বিভাগ বন্টন করিয়া লইয়া তারপর কনস্ট্রাকশন করিবার জন্য বলিলে উক্ত বিবাদীগণ দম্ভরে তাহা প্রত্যাখ্যান করেন এবং বাদীকে প্রয়োজনীয় আদালতে আশ্রয় লইবার পরামর্শ দেন। So, my lord, at the inception of when they started, my lord, digging the earth, my lord, immediately thereafter, my lord, I filed this suit for partition.
Yes, Mr.
But
Shanal.
kindly consider, Lordship,
No,
the
Mr. Shanal, you have not stated that they have also constructed.
but Lordship, kindly consider, Lordship, the date, Lordship, which has been mentioned, Lordship, that on after, Lordship, 2nd of April 2021, they was compelled to file this partition suit. But thereafter, Lordship, another advocate notice was sent on 9th of April,
Maybe.
which we was received, Lordship. But by that time, Lordship, that we have received the summon of the partition suit, the partition suit with injunction, Lordship, the construction was raised.
That's not.
So
That's
Lordship,
not them sitting quiet for a long time and allowing you to. They had resisted from the inception. In the Supreme Court judgment, they had the other side had kept quiet for a long time and allowed another to deal with the properties exclusively.
But Lordship, it was not
Here
right
they have
that.
protested from the inception.
But inception, Lordship, according to the plaintiff, Lordship, but in my objection, it is not rightly, Lordship, stated. But Lordship, the construction has been raised by that because Lordship,
You
we
have not even stated from when you started construction.
that part has not been that
Then
I cannot, Lordship,
How
input.
can
But
we hold even on facts that quite for a long time they were sitting tight? No, Mr. Shanal, no interference in this. We'll record his submission. We are
Because-
disposing of the appeal itself, Mr. Shanal and Mr. Ganguly. We'll set aside that portion, the other plot. But this we won't.
Then, Lordship, only one thing, though, liberty to, Lordship, approach before the learned trial court to approach under, Lordship, 39 Rule 4.
That liberty is always there if you have that liberties.
Yes.
Learned no, on consent of parties. Achana, the appeal involves questions of fact and of law, and as such is hereby admitted for being heard on all the grounds taken in the memorandum of appeal. To sub next para on consent of parties, comma, the connected stay application and the appeal are taken up together for hearing. To sub next para, learned counsel for the appellant submits that although the schedule of the plaint mentioned only one LR DAG number being number 365 stroke 1032 comma in the injunction application comma an additional plot being number 1258 was inserted and injunction obtained on the same. Full stop. As such comma the injunction granted by the impugned order is beyond the plaint prayers. Full stop. Next para. Secondly comma it is contended that the appellant has been residing in a mud hut on one of the portions of the suit premises. Full stop. It has been pleaded in the written objection of the appellant in the court below to the injunction application that on oral consent of all the other co-sharers, comma, the appellant has been residing in such portion. Full stop. Since in view of the marriage of the son of defendant number 3 and children having been born, comma, the need, the requirement for further rooms came up, comma, for which Pakka construction was started to be made adjacent to the mud hut. Full stop. Next para. After construction was made substantially in respect of the ground floor, comma, but before the roof of the said floor was cast, comma, the present suit was filed and an injunction obtained. Full stop. It is submitted that as such, comma, the balance of convenience and inconvenience as well as equity lies in favor of permitting the appellant to complete the construction. Full stop. However, comma, it is submitted that in the event the suit is ultimately decreed against the appellants or the portion on which the construction is made is not allotted to the appellants, comma, appropriate the appellants are agreeable to appropriate orders being passed with regard to the construction. Push up next parallel and counsel for the appellant cites such and such reported at 2008-11 SCC 1 for the proposition that grant of injunction is an equitable relief and a person who had kept quiet for a long time and allowed another to deal with the properties exclusively, comma, ordinarily would not be entitled to an order of injunction. For sub next para, learned counsel for the respondent submits, the learned counsel for the plaintiff respondent submits. How many plaintiffs?
Lordship,
One.
Acha. Plaintiff respondent submits that insofar as the insertion of the additional dag stroke plot in the schedule of the injunction application is concerned, comma, the respondent is agreeable to the said portion of the injunction being set aside. Full stop. Next para. However, comma, by placing reliance on the averments made in the plaint and the injunction application, comma, it is argued by the plaintiff respondent.
So only one thing, Lordship, may I?
No, not now. Plaintiff respondent submits that the plaintiff respondent has categorically averred that from the inception of the attempts by the appellants to make such construction, comma, resistance have been put up by the plaintiff stroke respondent. Full stop. As such, comma, the ratio laid down in the cited judgment does not apply. Full stop. Next para. Upon considering the materials before us, comma, we find that the plaint schedule incorporates only one plot number bearing 365 of 1032 at the relevant MOSA, whereas in the injunction application, an additional plot bearing number 1258 has been incorporated and injunction has been granted by the impugned order in respect of both the plots.
1284.
1284, what is, you say something else?
1284 is the malad that was incorporated.
That was inserted.
Yes, that was additionally.
1285.
1284 হবে.
58.
1284. Thank you. 1284. The next para. As such, comma, since the prayer made in the injunction application with regard to the additional plot is concerned, comma, learned counsel are justified in submitting that the said part of the injunction application ought to be modified by restricting the injunction granted to the suit plot number 365 by 1032. Push up next para. However, comma, with regard to the second contention of the appellant, comma, although the appellant has sought to impress upon the court that the plaintiff has made construction on his portion of the property and is now resisting the defendant's appellants from doing so, comma, we do not find any such averment having been made in the written objection filed by the defendant's appellants in the court below. Push up also, comma, there is no specific mention as to the date from which the construction was started in the written objection filed by the defendant's appellants is in the court below. Push up rather, comma, in the plaint as well as the injunction application, comma, it has been categorically averred that the plaintiff has been resisting the attempted construction from its inception and ultimately filed the suit. Full stop. Next para. Hence, comma, the ratio laid down in Mandali Ranganna Supra is not applicable. Full stop. In the said case, comma, it was held that a person who had kept quiet for a long time and allowed another to deal with the properties exclusively ordinarily would not be entitled to an order of injunction. Full stop. As opposed to the said case, comma, we do not find any foundational ingredient even in the appellant's pleadings in the court below to justify the contention that the plaintiff had sat tight for a long time and allowed the defendants to make such construction. Full stop. Next para. That apart, comma, in normal circumstances, comma, one of the co-sharers cannot be permitted to make a construction over his or her chosen portion of the property, since each and every co-owner has right, title and interest over every inch of the joint property. Full stop. That apart, comma, we do not find any illegality or irregularity in the order of the trial court for us to interfere. Full stop. It is right law that even if an alternative view is possible on the materials on record, comma, the appellate court does not substitute its own views for that of the trial court merely because such second view is possible, comma, unless there is some palpable illegality in the impugned order of the trial court. Full stop. Thus, we do not find otherwise any such illegality in the impugned order apart from the additional plot as indicated above. Full stop. Hence, FMAT 311 of 2023 is allowed in part, thereby modifying the impugned order and restricting the operation of the same to the suit plot bearing LR dag number 365 of 365 stroke 1032
1032.
and hereby holding that the operation of the injunction insofar as the additional plot number being LR dag number 1284 is concerned, the injunction in that regard is hereby set aside. Full stop. Next para, it is made clear that the findings rendered above and in the impugned order are tentative for the purpose of the suit, and the learned trial judge shall be at liberty to decide the suit independently in accordance with law without being influenced in any manner by any of the observations made here. Full stop. Next para, needless to mention, nothing in the above order precludes either of the parties to seek subsequent variation stroke modification of the order in the event the parameters of Order 39 Rule 4 of the Code of Civil Procedure are satisfied. Can 1 of 2023 is also disposed of accordingly, no orders to cost.
It will be 365 stroke 103. 103.
That is what you have said.
Yes. Grateful.
Judgment.
But tenant is the appellant before your lordship in a suit for eviction, my lord, whereby
What is the defect, Mr. Basu?
the defect has been cured.
Cured.
I've been told that this
Just check.
deficit code fee chilo. But I've been told that there is a deficit code fee which has been put into, and there was a defect as to the date of the degree. The date of degree was not required to be given because the date of the judgment bears the date of the degree.
We have carried out that correction.
My
Yes,
lord,
we have.
Yes.
Yeah. Yes. Move on.
But this is a suit for eviction.
Yes.
I am the tenant appellant before your lordship.
Both courts.
Both courts. I tell your lordship the infirmity.
On what ground?
But not the reasonable requirement that there was a previous remand. I tell your lordship the facts. Suit was degreed. Appeal was preferred by the
Only on ground of reasonable requirement.
reasonable requirement as well as default.
Initially. Then
And there was a change of mode of user that was not being praised by the plaintiff landlord. But the suit was degreed in favor of the plaintiff. Defendant preferred a title appeal. Title appeal was remanded to the trial court only on the ground that there was an application of Order 16 Rule 14 for taking an evidence of the landlord's daughter who collected the rent for and on behalf of the original landlord on his death, because there was a prior agreement. Agreement was with the original landlord who stipulated that during my lifetime I will be collecting. On my death, my daughter will be collecting.
how was it relevant?
But I paid the rent to the daughter as per the agreement.
Oh, that default ground was related.
Yes, the default ground was related.
You wanted to call that daughter for
Call the daughter for the purpose of, although the rent receipts have been exhibited, but there was a dispute being raised as to the signature. So I filed an application under Order 16 Rule 15 for the being a necessary person to prove the signature in
You said that the daughter received on behalf of the landlord.
the daughter received as per the agreement, because the original landlord stipulated the doctor authorized the doctor to, his daughter to receive the rent.
Then after remand?
After remand, my lord, after remand the order was challenged. Remand order was challenged by the landlord in an appeal before your lordship. Honorable Appellate Court hold that Order 16 Rule 14 was not required to be gone into because the tenancy was fixed for a period of 5 years. In any way, this way or that way, the person who has collected the rent is not required to be come in the docs to prove the signature.
All right.
But with that observation, it was demanded to take into consideration default ground as well as the reasonable requirement ground. Afresh by the first appellate court.
Okay.
First appellate court only by one line said reasonable requirement has been discussed by the trial court. I need not go into it. So far as reasonable requirement is concerned, one line. And on the default, it reiterated what the appeal court has said, that it is limited for a period of 5 years. So this way or that way, 5 years has come to an end. So you are defaulter. But although I have been paying rent at
Defaulter, what do you mean? 5 years has come to an end. You are
5 years, 5 years, it is the interpretation of the first appellate court that the tenancy agreement is limited for a period of 5 years. That is the interpretation.
The 1997 Act suit.
1997.
You were a statutory tenant after that.
Yes, I am a statutory tenant. That is the infirmity that has been arrived at by the first appellate court.
What are you saying?
My lord, may kindly see.
Show us.
The order of the first appellate court after remand. My lord will get
So
it.
regarding reasonable requirement, you say it's a one-liner, therefore not adverted to.
Yes, the one line I will show it to you.
So that one line at first.
Yeah, 5.20 at internal page 8 of the first appellate court judgment.
Yes.
I am of the further considered view that the learned trial court has taken a reasonable view with regarding to the grounds, namely default in payment of rent and also reasonable requirement of the landlord in respect of the suit property. It would not be out of place to say that the other grounds, namely wastage, damage, or change of mode of user, has not been established properly, and the learned trial court has taken a reasonable view of these points too. This is the only observation. Only observation. Although remand order was that you should take into consideration everything. Plaint has not been discussed, W has not been discussed, commission report has not been taken into consideration. And on the point of default of payment of rent, 5.17. In my consideration, the period of tenancy was extended for 5 years from April 1999 in the tenancy agreement dated 23rd of April 1999. So it has expired on 31st March 2004. The appellant did not get the tenancy agreement renewed. In the tenancy agreement itself, Rekha Sarkar, whose daughter of the original, for whom I filed an application on Order 16 Rule 14 for proving the signature on the rent receipt, was not given any authority to enter new agreement. No new agreement is required. Thus, continuation of the payment of rent to her, if any, would not protect the appellant. With this observation, mainly after remand, the first appellate court has disposed of it.
No, what is the judgment of remand shows that?
Yes, my lord. My lord, may kindly take the stay application. It is at page 136. No, my lord, 142. Kindly come to 150. Third paragraph, 150, third paragraph. Since the entire order of remand was hovering on the circumference of the application under Order 16 Rule 14 of the Code, having not decided, and there is no finding returned on the other issues on the merits in relation thereto, the first appellate court, being the creature of the statute, is required to return its finding on all issues afresh, being the last court of fact and law. The entire issue becomes at large, and it is an ardent duty of the first appellate court to decide the appeal on the basis of the evidence adduced by the respective parties and the arguments so advanced. Since first appellate court has not decided the other issues, more particularly the issue relating to reasonable requirement and default.
Yes, seen it. Can you please take us to the finding of the trial court regarding default?
My lord.
Which has been affirmed here.
Yes, my lord.
Which gave rise to the problem in the first place.
Page 37 of the stay application.
No, give us the internal page.
Yes, my lord. Kindly comes to I'm fine. Thank you. Page 51. The relevant portion I am showing to lordship.
Regarding this default, actually.
Default, yes.
Rekha Sarkar, yes.
My lord,
Internal page 9, we see something.
Yes. My lord,
produce some rent.
Page 47, internal page 11. Last paragraph.
You had produced some rent receipt issues.
Yes, I have produced all the rent receipts that has been given by Rekha Sarkar, the daughter of the original landlord. All the rent receipts were marked exhibits.
Quote at page 9 says, I am not inclined to give much importance to those rent receipts in view of the fact that those have not been proved by the defendant by calling the required witness Rekha Sarkar.
Yes.
So that is why
I filed an application on Order 16 Rule 14. But those rent receipts have been marked exhibit. Subsequently, there is a dispute that these are not the signature of the one Rekha Sarkar to whom the tenant has tendered the rent.
At page 11, what does the court say? You are placing page 11, we disturbed.
Well, at page 11, last portion is the finding relating to the default. It is a case of the plaintiff that the defendant has paid monthly rent till January and April 2007, and he becomes a defaulter in payment of rent to the month of May 2007 till today. On the contrary, defendant has not specifically denied the same in the written statement, but denied it at the time of filing affidavit in chief. That defendant tries to establish that he is not the defaulter in payment of rent and he has paid the rent to Rekha Sarkar till December 2020. As on date, I am paying. I have the receipts with me. Who is also the landlord within the meaning of Section 2C of the West Bengal Premises Tenancy Act 1997, and his relationship still exists with Rekha Sarkar. In order to substantiate the same, the defendant filed some rent receipts alleged to be issued by Rekha Sarkar, which has been marked Exhibit D collectively with objection. It is settled law, principle of law, that the mere production and marking of a document as exhibit by a court cannot be valid to be a due proof of its content, and its execution has to be proved in its admissible evidence. But the situation is, however, different when the documents are produced. They are admitted by the opposite party. Signature on them are also admitted and thereafter marked exhibit by the court. In the instant case, the signature of Rekha Sarkar over these entities have been challenged. The owners of proof, in fact, lay on the defendant to lead additional evidence.
Lead oral evidence to show that, say that Rekha Sarkar was empowered.
Yeah, I want to prove the document, the signature on the rent receipts. Since they subsequently challenged.
No, this was reopened by our court.
By yes.
We are not bothered with that signature proof.
No, not
no. Our question to
you.
you.
Kindly see the last line of that paragraph.
Yes.
I am inclined to hold that the defendant is a defaulter in payment of rent from the month of May 2007.
No, we have seen that. Our question is whether you led any independence evidence to say that Rekha Sarkar was ever empowered by the landlord to collect.
The agreement I have
exhibited.
Yes, agreement has been exhibited. The kindly
agreement between landlord and Rekha.
Yes, original landlord and me.
The present second appeal shall be heard on the following substantial questions of law. Roman 1. Whether the first appellate court substantially erred in law in affirming the finding of the learned trial judge on the issue of reasonable requirement by a single sentence, comma, without adverting at all to the evidence adduced by the parties and or the material on record on such issue, as well as the legality of the findings of the trial court on merits on the issue of reasonable requirement. Roman 2. Whether the learned first appellate court substantially erred in law in overlooking the agreement exhibited by the defendant appellant, comma, between the landlord and his daughter Rekha, empowering the latter to receive rent on behalf of the landlord, comma, which brought Rekha within the purview of the definition of double inverted landlord of the West Bengal Premises Tenancy Act 1997, and as such negated the trial court's finding that the appellant was a defaulter in payment of rent. These two grounds. Any stay application?
Yes, madam. Kindly stay the title execution case number 4 of 2022. Kindly see the their portion.
Can 1 of 2024 has been filed praying for stay of the execution case levied in terms of the impugned decree of eviction. Push up next para, since we have already admitted the appeal, comma, we find that there is a strong prima facie case made out by the appellant for grant of stay. Full stop. Accordingly, there shall be stay of all further proceedings in title execution case number 4 of 2022, arising out of title suit number 118 of 2015, comma, pending before the what is the
third additional district judge, Barashat.
No, but third additional is the appellate court.
Yes, first appellate court has passed the order.
Execution case.
Before the title shoot. Civil first civil judge, senior division, Barashat.
Pending before the learned civil judge, senior division. Senior division, first court.
First court.
At Barashat, district North 24 Parganas, till disposal of the application. Push up next para. The petitioner, the appellant stroke petitioner shall serve a copy of the application on the plaintiff respondent, indicating that the application shall next be listed before the learned single judge having determination to hear the same, and file an affidavit of service to that effect on the next date of hearing of the application. For sub next para, it is made clear that it will be open to the respondent to argue the question as to whether occupation charges for grant of stay should be imposed as a condition of the grant of stay, comma, at the time of final hearing of the stay application.
Much obliged.
Lord, section 5 is there, so my lord, I will have to serve.
Oh,
Though, my lord, we have served, but then there was no
Without-
direction to serve. So
If they appeared, no difficulty.
yes, if they had appeared, my lord, though it's the Mantoshes, my lord, they do appear at times, but
It's against the Mantoshes.
yes,
Their parties.
yes, my lord.
Mr. Chatterjee did some cases for Mantoshes.
Doesn't matter. Everybody, my lord,
Has
this-
done cases. No, whether regarding this property. we
No,
don't
no,
know.
no. This is the first, my lord, because this is the first suit with
Regarding
respect
this
to
property.
property.
We'll serve copies of both the applications. The appellant shall serve copies of Can 1 of 2024 as well as Can 2 of 2024. This is a misappeal against injunction.
Yes.
As well as a copy of the memorandum of appeal on the respondents indicating that the matter shall be listed under the same heading. When should you keep it next?
7 days, sir.
Pardon?
7 days.
7 days you won't be able to serve.
My lord, in Calcutta, we'll serve it by hand also. Courier.
We'll keep it after a fortnight.
Because the problem is, my lord, now it's become really urgent. Let me try till 7 days, then after, my lord. No.
Listed next under the same heading on very well, May 13, 2025. When an affidavit of service to that effect shall be filed by the appellant.
So grateful. My lord, allows me to serve by email and WhatsApp as well.
We have not specified the mode. Serve whatever manner. You call Mantoshes and tell them to come.
Yes, I'll
when
do
they
that.
are ready. That's the easiest way
If
to
the
serve.
brother was alive, it would have been much easier.
Yes.
So nowadays, my lord, because he used to look after their
Yes,
legal part.
Yes.
But now it's become difficult. David
Appreciated.
was.
Number 12.
And I'm for the husband appellant.
Husband, Mr. Haldar, what is the
Husband
defect?
plaintiff appellant, brother.
Pardon?
So, husband
No,
plaintiff.
defect.
Defect is, malad, so there are 3 defects.
Apart from that, you being a husband, any other defect in the appeal? Deficit court fee has been paid.
Has been paid. So far as the classification of the
Yes.
appeal, malad, it should be malad FAT because against the malad judgment and decree of the appellate decree. Matrimonial suit dismissed.
You have scored through decree and written order.
Malad,
Originally, it was decree. That has been cancelled and you have written order. So, therefore, no admission is necessary then.
No admission is necessary.
We'll direct your learned advocate to rectify and put this as application tomorrow. Sir.
Malad.
It should appear for the appropriate under the appropriate heading for them to be aware.
Malad.
Because somebody won't be looking out
Malad,
for.
another defect is that malad, so far filing of certified copy of the decree. Because malad, the decree has not been drawn up till date. Malad, this is one of the matters of Bankura. Malad, I seek some time. Malad, at least 1 month.
At least a month.
At least a month.
Then we'll let it go out of the list for the present with liberty to mention. The appeal remains defective.
Malad.
This is against matrimonial.
Matrimonial.
Divorce granted or refused?
Refused.
Refused, then you can wait for a month. If it was granted, then he would have remarried or she would have remarried. We find from the tenor of the appeal, TNR, that the same has been preferred against decree dismissing the plaintiff appellant's suit for divorce. Full stop. As such, comma, the appeal ought to have been classified as a regular first appeal. Full stop. We grant liberty to the learned advocate on record for the appellant to carry out the necessary correction in the classification of appeal in the memorandum insofar as it should be classified as a memorandum of appeal from original double inverted decree, double inverted clause instead of double inverted order. Full stop. Next para, such amendment shall be carried out during the course of the day. Full stop. The department shall classify the appeal as a regular first appeal and allot an FAT number thereto within a fortnight from date, full stop. Next para, insofar as the filing of the certified copy of the decree of the trial court is concerned, comma, learned counsel for the appellant seeks some time to file the same, full stop. Accordingly, let the matter go out of the list for the present with liberty to the appellant to mention the application for inclusion in the list as and when the certified copy of the trial court's decree is filed. Full stop. Upon such certified copy being filed, comma, the office shall furnish a fresh report in that regard. একটুখানি সাইড করে দিন তো, দেখতে পাচ্ছি না, ইয়ে কম্পিউটারটা দেখতে পাচ্ছি, স্ক্রিনটা দেখতে এখানটা রেখে ওখান থেকে আবার আচ্ছা আপনাদের দিতে শুরু বাবা ফিল্ড ডিফেক্টিভ আছে কি ডিফেক্ট দেখেন কোনটা ক্লিয়ার করতে হবে You're appealing?
My lord, it appears from the cause list that the matter is defective.
What is the defect you have to check up?
I am not check up. I am not check up.
It's a personal matter?
No.
So
I pray this maybe not today.
No, we'll just check up what is the defect so that we can help you. Inter judgment of the first appellate court was not filed, second judge's copy was not filed. Without curing we had directed you on 16th April 2025. Why didn't you do it? Second judge's copy এখন ফাইল করেছি রয়েছে আচ্ছা ইন্টার জাজমেন্ট দিয়েছি কি ডিফেক্ট দেখছি revised report certificate now informed names of parties are found correct. Our revised report such a judgment has been filed on ATO along with second judge's instant appeal is in form now. Preamble is bereft of the details of the trial court. আরো আছে the phrase mentioned in the first line in the preamble impugned judgment
replaced by impugned judgment and decree.
Have you got a copy of the memorandum?
No.
Carry out the necessary corrections. Two corrections in the first line of the preamble of the memorandum. You have written judgment and order. That has to be judgment and decree. And you also have to insert the details of the trial court's judgment.
Last is order not yet.
You are the advocate on record. Who is the advocate on record? Who are you? How are you connected with the matter?
I am the junior of my advocate on record, Mohammed Hossain.
Who is the?
Yes, instructed me not to do it.
The learned advocate for the appellant is directed to carry out the necessary corrections to the memorandum of appeal by inserting the particulars of the judgment and decree of the trial court as well as by rectifying the preamble of the memorandum to the effect that the impugned judgment and decree should be mentioned as such instead of within double inverted judgment and order, double inverted close, full stop. Such corrections shall be carried out. When should you keep it? Is your advocate on record in court today?
Today.
Your advocate on record, your senior has come to court today?
No.
When will he come? Next?
Next, one
shall be carried out within a week from date, full stop. Let the matter be listed under the same heading on May 14, 2025. Carry out the correction as soon as possible.
My lord, I am for the appellant.
Yes, yes. What is your matter?
Yes, my lord.
Against
This
injunction, grant or
a
refusal? Or
refusal of ad interim order.
ad interim order.
Yes, my lord. My lord, the facts of the matter, my lord, may I precisely submit? The
Yes.
plaintiff is a LLP Bombay limited liability partnership firm, my lord, Bombay-based firm, and the plaintiff number 2 and 3, my lord, are the partners and son of one Rajiv Mohta.
All right.
Now the plaintiff number 1, my lord, had a property at Lord Sinha Road. A long-term lease was granted in his favor. That was ultimately surrendered in favor of the owner in 2023. Upon surrender of the property, the plaintiff number 1 got, my lord, 2 crore 40 lakhs rupees. From that proceeds, a flat was purchased by partner, that is the father of the plaintiff number 2 and 3, one Rajiv Mohta. My lord, he had purchased a flat in Alipur for a sum of rupees 2 crore. Now the defendant number 1, my lord, is another woman, a women friend of Mr. Rajiv Mohta.
What is the meaning of women friend? Friends are friends.
My lord, they were living together.
Very well.
Yes.
Don't be so shy about it. They were living together.
Yes.
Their choice. You are not living
No,
together.
we don't have any
Don't be
objection.
shy. Yes.
Now, my lord,
Rightly living together. Yes. So what?
my father died in Lord August 2023.
All right.
Now thereafter the dispute arose, my lord. Now the plaintiff case is particularly the plaintiff number 1. He claims ownership of the flat.
One is the LLP.
LLP.
It claims ownership of the flat.
Of the flat. Now the flat has not yet been. The flat was purchased from
How
a
does the plaintiff number 1, the LLP, become the owner?
My lord, because
it was purchased with its money.
Yes, because of the sale, because of the
those proceeds being
proceeds
used
of the
utilized.
Lord Sinha Road property. My lord, we have produced the document before the learned trial court, my lord. So this is our case.
Your
that
suit is for what? Declaration of your title.
Declaration of title, recovery of possession, and injunction.
Acha. No, acha, very well. No, this lady, number 1,
Yes.
respondent number 1, she was living together with one of you.
No,
Father.
with my father who
Acha,
died.
father. Very well.
Who died.
So
now she is under occupation of the flat.
Respondent number 2 is, I mean,
is the developer. Is the developer from through whom my father entered into an agreement. Now this is a unregistered agreement. Agreement was
your father never purchased the property.
He had paid the consideration amount, 2 crores.
So don't have a present title. You have an actionable claim. Did you file any suit for specific performance regarding that agreement?
No.
What is your present right to get an injunction? You don't have title. Your father also did not have any title.
But the possession was.
You had an agreement.
Possession was given, and he was enjoying the property.
Then how could the respondent number 1, come in possession?
They both were living in that flat.
Acha.
This is our case.
So, but now the LLP and you.
Yes.
If your father was alive, he could not have evicted her.
Yes.
Because he was never the owner of the property.
Correct.
So why was it refused?
The ground of
absolutely.
refusal. Yes,
Right.
Lord, kindly take the.
It appears that registration of deed is not yet completed for each matter of the.
Yes. Lord, I have produced the copy of the money receipts issued by the defendant number 2, recording the description details of the flat, suit property, and the money transaction. And I have also produced bank statement showing that the proceeds from Lord Sinha property received by the plaintiff number 1 and subsequently given to the father of plaintiff number 2 and 3.
Your best case is that,
yes,
first of all, your father purchased in his own name.
Yes.
Rather entered into an agreement in his own name,
Yes.
not as a partner of that your LLP.
Its own name, not so far I came.
And the concept of LLP is not like an usual partnership.
Yes.
It has elements of both a company and.
Right.
So if that be so, first of all, there is some doubt as to what right the LLP has in that. It might have been purchased from the funds of the LLP. You have may have got a prima facie case. but yet it's an inchoate right. Secondly, your father entered into an agreement. Let us proceed on your best case. Your father entered into an agreement, paid money, got possession in terms of that agreement.
Yes.
Neither of these things confer title on the property on your father.
No, here there is some dispute. The developer told me that the agreement was entered by the defendant number 1 and my father.
Then also that goes against you also.
Yes, as purchaser. My lord, I had a limited prayer before the trial court while pressing for the interim relief that for the time being kindly restrain the defendants from creating any third party rights over the property because it will cause multiplicity of proceeding and other.
You don't have a prima facie case. You don't have title in the property. You had an actionable claim at best. If you had an actionable, when did your father die?
My lord, even
When did your father die?
my lord, in 9th August 2023, 2024.
2024. So you still have time to file a suit for specific performance. But without that, you don't have a present right in the property. Your father did not have a present right in the property. An actionable claim.
But my lord, he was...
Unless you were a true owner. And LLP has nothing. LLP at best if you agreement holder, and in agreement there is privity of contract between the parties. If you want to enforce an agreement, the LLP, there is some doubt whether the LLP can enforce the agreement entered into by your father. And also this lady, maybe.
Yes. And my lord, and being heirs of Rajiv Mohta, my lord, if for a moment, if I keep aside the...
Yes, you have a better case as heirs.
Yes.
But you have not filed the suit as heirs. The frame of your suit is that you are...
No, in the plaint I have stated my relation.
You have also
Plaintiff number
claimed as
2 and
heirs.
3 are parties
Very well.
to the suit. Plaintiff number 2 and 3 are parties to
You
the suit.
claim through the father.
Yes.
Let us see your plaint.
Yes. Well, the plaint melody is annexed at page 73. 73, my lord.
Right. Co-agreement holder is equivalent right. Same footing. Sorry. Page 70.
73, my lord. Plaint is annexed in my CAN application, my lord, page 73. My lord, at paragraph 4, my lord, I have the relationship, my lord, with the Rajiv Mohta have been disclosed.
Legal heirs of Rajiv হিসেবে ক্লেম করেছে অ্যাডমিট করে একটা ইনজাংশন দিই কেননা এদের ইয়ে রয়েছে থার্ড পার্টি ইন্টারেস্ট চাইতে পারে you have also prayed for injunction against the developer.
Yes, my lord, because my lord, the registration has not taken place. Registration has not taken place, and
Against defendant number 1 we can understand, but you have not filed any suit for specific performance. Where is the bar in the developer doing it? You have not even prayed, and this suit, your suit is for declaration and injunction only. You have not asked for performance of that agreement.
no specific performance, my lord, I have not.
So in the absence of that, how can the developer be restrained? Anyway, ad interim will grant ad interim. The appeal will be heard on the grounds taken in the memorandum of appeal and is accordingly admitted. Full stop. Next para. The appellants have made out a case in their plaint to the effect that that the father of the appellant numbers 2 and 3, one late Rajiv Mohta, had entered into an agreement with the respondent number 2, comma, a developer, comma, to purchase the suit property and had paid a substantial portion of the consideration amount and got possession. For sub next para, it is the further plaint case that such consideration was paid from the funds of the plaintiff stroke appellant number 1 LLP, comma, obtained upon surrender of a different property by the LLP. Full stop. Instead of entering into such agreement on behalf of the LLP, comma, it is alleged that late Rajiv entered into the agreement in his own name. Full stop. Next para. The plaintiff stroke appellant numbers 2 and 3 claim in the capacity of claim, comma, inter alia, comma, in the capacity of the heirs of the said Rajiv as well. Full stop. Next para. Although the developer is seeking to make out a case that the agreement was entered into between the developer, that is respondent number 2, and Rajiv, comma, the deceased father of the appellant numbers 2 and 3 on the one hand, and respondent number 1 on the other, comma, who was living together with the father of the appellant numbers 2 and 3, comma, it is argued that even if that be so, comma, the appellant numbers 2 and 3 stand on similar footing as the respondent number 1. Full stop. Next para. We find from the records that a strong prima facie case has strong that a prima facie case to go for trial has been made out in the suit by the plaintiffs, inasmuch as certain valuable rights and stroke or actionable claim has been created in favor of the arguably in favor of the LLP through the deceased father of the plaintiff numbers 2 and 3, comma, who prima facie acted in favor of on behalf of the appellant number 1 LLP, comma, we are of the opinion that the learned trial judge prima facie erred in law in refusing ad interim injunction. Full stop. Next para. Accordingly, we pass an order of ad interim injunction restraining the respondents from dealing with, comma, transferring, encumbering, alienating, and or creating any third party interest in respect of any stranger to the suit till disposal of the application. Full stop. The appellants shall serve copies of the application as well as the memorandum of appeal on the respondents, indicating that the application shall be listed for hearing on May 19, 2025, when an affidavit of service to that effect shall be filed by the appellant. Grateful.
My lord, in item number 2930, I appear for the appellant.
Yes.
Being led by Mr. Chaudhary in this matter, my lord.
Which Mr. Chaudhary?
Mr. Shobhoshachi Chaudhary in this matter,
Yes.
my lord. He's at his legs before court number 36. I am praying for an adjournment, my lord. And if it can be kept on Wednesday.
But I am appearing for defendant number 8.
Why not tomorrow?
Tomorrow he has a fixed matter before Justice Mantha. So
what are the defects that has just checked up?
there is one defect, my lord. It's for item number 29, the FMAT 127. So we have impugned the parent injunction order as well as the subsequent extensions. The last extension is part of the new appeal, my lord, the 141, item number 30. So maybe a defect for that has come, for which I filed a continuation application.
Very well. On the prayer of the appellants, let the matter stand adjourned till May 7, 2025.
My lord, I have also have the affidavit of service if it can be taken on.
Affidavit of service filed today be kept on record.
Grateful, my lord.
Deeply grateful. Thank you.
If it pleases your lordships, my lord, I beg to appear for the appellant, my lord. The appellant before your lordship is a wife, my lord.
Right.
It's an appeal directed against an order of dismissal of an application under Order 9, Rule 13, preferred by the wife against an ex parte decree of divorce granted to the petitioner husband, my lord, under Section 13(1), subsection 1A, that is the ground of cruelty under the Hindu Marriage Act 1955. Now, my lord, that application.
Condonation application.
Yes, my lord, I should mention before your lordship that there is an inordinate delay of around 6.5 years or so, my lord, in preferring this appeal, my lord. My lord, the appellant before your lordship is a maid servant, my lord. Her husband is an auto driver, my lord. My lord, she
might have remarried in the meantime.
But that is the only solace, only bit of hope. Not remarried, my lord. My lord, there is an
Soft copies and come back.
There is an application, my lord, for injunction, my lord. If your lordship is kind enough to, my lord, grant a limited stay, my lord, from injuncting.
Section 5 is pending.
Yes, I understand.
For such a long delay, no.
My lord, if
valuable rights might have been.
My lord, that's true, my lord. I bow down to every observation of your lordship, but kindly, my lord, visualize, my lord. If the husband remarries, my lord, nothing would remain, my lord.
For 6.5 years, if you could wait, I mean.
My lord, kindly consider, my lord.
The petitioner shall serve copies of the applications on the respondent, indicating that the application shall be listed next on May 19, 2025, when an affidavit of service to that effect shall be filed by the appellant.
The status quo, my lord, kindly, my lord.
No. 19th.
I'm so grateful, my lord. I'm so grateful.
For small delays, we
I
would have done.
understand. I understand. I
6.5
completely bow down. I completely bow down. So grateful.
Lordship, I beg to appear on behalf of the appellant.
Before my learned friend comments his argument, my lord, I have preliminary objection as to the maintainability of this appeal as on this date.
Why
The subsequent extension of the order which I have
The order was up to 2nd May. And my learned friend's client entered appearance in the trial court and filed an application under Order 39, Rule 4. And my lord, the next day, and my client also filed an application for extension of the interim order. The learned judge in charge of the learned district judge at Bardhaman, my lord, extended the interim order up to 11th June. And my lord, both the applications were fixed on that date. So my lord, the order impugned, my lord, before your lordships, that is up to, the effect was up to 2nd May.
If it has been extended, Mr. Rai, the effect continues still.
But my lord,
if
there
this
is
order goes, the extension.
There is no appeal, my lord, before your lordship with regard to the.
Even then, our view, Mr. Rai, is that the basis of the extension will go if this order goes.
But my lord, this order definitely, my lord, but my lord, if an separate appeal is filed, my lord, the second part of the order, which was, my lord, extended the interim order on 2nd May, there is no appeal before your lordship. My lord, the order which was.
If the premise of this order goes, Mr. Rai, in our view, the extension will also go.
Like
because the extension is of an order which.
Subject to your lordships.
If the first order becomes 0.
Yes. Now, my lord, subject to your lordship's correction, my lord, if the.
This is against challenge against the main order.
Yes. The ad interim order which was granted.
So if it was the other way around, then we could have agreed with you.
But the extension, order of extension, that is not appeal against.
Not be. This order goes.
No appeal, my lord. But my lord, it was a limited with the order, my lord, spend it for my lord, life on 2nd May.
We'll record that, we'll deal with that and then take up the matter.
But that is up to your lordship.
Learned counsel, learned senior counsel appearing for the plaintiff's
Plaintiffs number 1, 2, and 3.
Yes. Learned senior counsel appearing for the plaintiff respondents numbers 1 to 3 takes a preliminary objection to the maintainability of the appeal. Which of the appeal has been preferred against an ad interim order of injunction. Push up. Learned senior counsel submits that since the impugned order was passed up to May 2, 2025, that is for a limited period, and since it has since expired, the appeal is no longer maintainable. Which of next para, it is submitted secondly that the ad interim order granted by the present impugned order was subsequently extended. Which of in the absence of a challenge against the said extension, the present appeal would not serve any fruitful purpose, since even if the appeal succeeds, the extension order would remain on record. Which of next para, however, we are unable to accept either of the contentions of the plaintiff's respondents. Next para, in the view of this court, in the event the present impugned order goes, the very premise of the subsequent extension of this order would also be gone. Next para, as such, since the parent order itself has been challenged by way of the present appeal, we are of the opinion that mere extension, mere subsequent extension and lack of challenge to the subsequent extension order does not vitiate the maintainability of the present appeal. Next para, insofar as the impugned order herein having been passed for a limited period, the other argument of the respondents is self-defeating, since by virtue of the extension, the life of the present order has been extended, and as such, the relevance of the present appeal still remains. Thus, we hold that the appeal is otherwise maintainable in the eye of law. Since questions of both facts and law have been urged in the appeal, we admit the appeal to be heard on the grounds taken in the memorandum. Now on the stay application. Yes, what is the merits of your appeal?
Yes, Your Lordship, I am against the order of ex parte ad interim injunction, where my learned friend's client, who was a erstwhile secretary of a society, has been reinducted. He was terminated by issuing 4 show cause notices, and thereafter after 14 months he comes up with this suit.
One second.
Yes.
Admission of appeal je last order ta dilam na, in view of questions of both, ota kete din. We have not yet admitted the appeal. We'll hear you and then
Yes.
we may not admit.
Yes.
Yes.
Yes. Now he comes up after 14 months.
Sorry, please repeat once. We just lost
Yes,
track.
this is against the ad interim order of ex parte injunction,
Yes.
wherein my learned friend's client, who was a erstwhile secretary of a society, has been reinducted in the society. And now
Reinducted by virtue of this order?
Yes, yes, I'll show.
In
I'll
the nature
show.
of a mandatory order?
Yes, that will be my ground, that couched in the form of an interim order, a final relief has been passed. That too, no urgency has been pleaded in the injunction application. A mechanical copy paste of the plaint has been done in the injunction application, and no exigencies or good grounds were shown, so that he could have again reinducted. Now there were 4 show cause notices, Your Lordship, by which this gentleman and a member was removed. Now after 14 months of their removal, they come up with this suit. I didn't lodge a caveat. Naturally, he had moved this ex parte and obtained the order that he can participate in the affairs of the finance and the affairs of the society.
He was removed by a formal resolution?
Yes, yes.
Did he disclose that in the application of
the plaint and petition? That will be also one of the ground of challenge of my client before Your Lordship, that the plaint is a very peculiar plaint, Your Lordship, but because it does not adhere to Order 7, the requirements under Order 7, Rule 14. They have not disclosed what the documents they are relying upon, or the documents which they have relied upon in the injunction petition. That too were not served upon us. That is the specific challenge which we have also taken in our.
Rely on documents in the plaint.
There is no mention in the plaint.
They
Your
don't
Lordship.
really rely on any documents. We'll have to consider on
But the learned court below has taken into account some documents which I do not find in the Jurhat portion of the plaint or the petition. Only the body maintains certain complaints were made before the statutory authorities and nothing more than that. Your Lordship, on the last occasion when this appeal was heard by Your Lordship, my learned senior friend had taken a point that this is a suit under a special suit under the provisions of section 92 of the Code of Civil Procedure, and that leave was obtained. Now, that is also not under challenge before Your Lordship, but I will show from the plaint to Your Lordship that this is a simpliciter vindication of personal rights, that he has been removed from his office and he wants a reinstatement and he wants to participate in the affairs of the society. He has not claimed for formation of any scheme or the dissolution of the society or any allegation that we are defalcating funds, and thereby, since many colleges are run under this society.
or the management of the society.
Yes, yes. The only problem.
Only that he has been wrongly
removed, and he shall be entitled to function as per the memorandum of association of the society. Your Lordship, may I take Your Lordship to the plaint, Your Lordship, for once?
Yes.
It starts at page 40. 40, 41, 42 is the area of parties. Your Lordship would kindly see, this is a suit for declaration and permanent injunction that is captioned like this. Now, Your Lordship, the para number 1 is very important. The plaintiff is a society named and styled as so-and-so, has been created by plaintiff number 2, who is the ousted society, the secretary. And the defendant number 1, yes. Yes, defendant number 1 is the present treasurer of this society, Your Lordship. Yes. Together with some members for charitable purpose. The same was duly registered before the office of the Registrar of Firms, Societies and Non-Trading Corporation, Kolkata, West Bengal on 23rd September 2003, bearing so-and-so registration number. Under, Your Lordship would kindly take a note of this line, under the provisions of West Bengal Societies Registration Act, 1961.
Yes.
Thereafter, the founding members and the constitution of the societies is there. Now, what is their cause of action? Your Lordship would kindly see at page 43, para 6. That after the formation of the committee, office bearer of the said GSS, the plaintiff number 2 secretary has convened different meetings in the office premises in the said Shomiti. The plaintiff number 2 secretary expended huge amount of money from his own pocket for the development of the Shomiti on the initiative mainly the plaintiff number 2 secretary as well as the said committee established so many institutions for the benefit of general public. Now, for the first time in this plaint, he mentions about that so-called public element. I shall be pointing out. There are only 2 instances where this so-called public element has been pointed out and the 92 leave has been obtained. Now, the colleges which are run under this society are named in the following paragraph. Now, kindly see page 44, para 7 of the plaint. During the term as secretary of the plaintiff Shomiti,
he's with you. She's with you. Ms. Agarwal is
No,
with you. Sir, we can hear you. We can't hear him.
Yes.
Yes.
I'm sorry, Your Lordship.
She should be sorry, not you.
I'm sorry.
Yes.
That during the term as secretary of the plaintiff Shomiti, the defendant number 1 and 2 since the first part of the year 2024, Your Lordship would kindly take a note of this year also, 2024. Not cooperating and consulting with the plaintiff number 2 secretary for smooth and proper functioning of the said Shomiti, which is contrary to regulation so and so. The plaintiff number 2 secretary did not doubt in such gestures of the said defendant number 1 and 2, as they are nearest and dearest one having full confidence and faith upon them. So this is the first instance when they complain that there are some problems which are arising in the society. Your Lordship would be kindly taking page 45. This is a big paragraph. That on and from, Your Lordship would again kindly mind the date, 6/2/2024, defendant number 1 and 2, their men, without any reason, forcefully prevented the plaintiff number 2 secretary to enter into the office premises described in the schedule below, for which the plaintiff number 2 secretary lodged a complaint before the district magistrate, superintendent of police, OC, BDO, MLA, so and so. Thereafter, all on a sudden, the defendant number 2 sent a letter bearing so and so. This is the termination letter, Your Lordship. Your Lordship would kindly mark it. To the plaintiff number, sir, to the plaintiff number 2 secretary and his son plaintiff number 3, mentioned in the said notice that the authority to issue termination notice upon both the plaintiff number 2 secretary and his son, member of GSS, and also mentioned in the said notice a meeting was conducted on 6/2/2024. This is admitted, Your Lordship. On 6th of February, this meeting was conducted. And also mentioned in the said notice that if plaintiff number 2 secretary and his son are dissatisfied with the termination notice, plaintiff number 2 and his son may apply to the president for formation of standing approval committee. That was the appellate committee which we had intimated him that he can appeal against the decision by which he was removed from 7 days from receiving of that notice. But as a matter of fact, the meeting as mentioned in the meeting was contracted on this gets a bloody, and there is no standing appeal committee in spite of defendant number 2, the said notice to the plaintiff number 2 and 3 without giving any opportunity of being heard to the plaintiff's termination notice dated so and so is illegally and arbitrary, and for some unlawful game, the said termination notice dated so and so does not stand and not binding upon the plaintiff number 2 and 3. Now this goes on to narrate that the so-called illegalities which have been committed by my client. In short, he challenges his removal, which is he says that he was prevented, forcefully not allowed to enter into the place where this meeting was going on, which I will also show that this did not happen in the suit schedule premises. It took place in a place which was, ma'am, Mr.
Yes, yes, Mr. Vasu.
Yes. Well, I am only simple point of urgency. This incident happened according to the plain case is 7th April 2024. 7th February 2024. Well, kindly come to the injunction application. Injunction application is a replica of
page 53
of plain.
Starts at page 53.
Can I take it from me for the time being? That is a replica. Only paragraph.
Page 57.
Kindly come to page 57
and 56.
I am reading from my lord, page 56, paragraph 10. The plaintiff said that the alleged secretaryship, if the defendant number 2 is in contravention of memorandum of association and the rules of regulations of 23rd September 2023, and further the act of defendant number 2 as secretary in respect of the control, including the financial control, supervision, illegal and committee. It is also stated that the letter number such and such dated 7th February 2024 is bad, illegal and binding, not binding. Under these facts and circumstances, a decree for declaration that the plaintiff number 2 is successful. So this is the main prayer. Can it turn over? Paragraph 12. That the cause of action of the suit arose on 7th February 2024. Then, that unless the order of temporary injunction is granted in favor of the plaintiff, they will be seriously prejudiced and the defendant would continue to create obstruction to enter into the premises and will also interfere with the power as secretary. There is sufficient urgency to grant temporary injunction. This is the pleading. Occurred in 7th February 2024. Now, my lord, kindly see where from the learned judge kindly come to the order impugned now. My lord, learned friend has placed, my lord, kindly come to internal page 2 of the memorandum of appeal.
57.
Key. No, no.
Yes.
Now, my lord, kindly come to internal page 2, last part, one paragraph. Since contention of the landed advocate for the plaintiff has Marakali got it.
Yes.
Is that the no notice that the 6th February 2024 was served upon the plaintiff, and it is further argued that there is no existence of appeal committee. Therefore, prima facie is established on basis of the documents filed that without giving an opportunity to plaintiff of being heard, any meeting held at the termination notice has been issued. So this is for my lord prima facie case. Then from the B schedule of the plaint, I find that there are as many as 29 bank accounts of the committee. Prima facie it is evident that there is misappropriation and mismanagement as because involved, therefore the balance of convenience. Where from my lord the learned trial judge got it? What is the allegation?
Misappropriation.
No allegation.
Only illegal removal of the.
That's all. So for the purpose of urgency, the court found that there is a chance of misappropriation. That's why interim injunction granted ex parte. There is no pleading. That's why he placed the pleading. It is plaint is replica, only 2 paragraphs, cause of action, and there is urgency. That's all. The basis of urgency, which prompted the court to pass an ex parte interim order, is lacking. There is no pleading also. If there is no pleading, my lord, it cannot be said. And what is the order? The defendants are hereby restrained from interfering with or creating any obstruction to the plaintiffs to enter into the office. 7th February 2024 discharged. Then, as mentioned, schedule A of the plaint, and further, the defendants are also restrained from interfering with the acts, function of the plaintiff to perform their duties as per their designation of the committee.
Registered officer না বসিয়ে পলিটেকনিক কলেজে ঢুকিয়ে দিয়েছে পুলিশ হেল্প দিয়ে।
That is post order, my lord, that has been done.
Yes.
So far as this order is concerned, my lord, at least on the basis of the urgency which not even pleaded, court has come to the conclusion that there is apprehension of multidary involvement. There's misappropriation and mismanagement is involved. There is no pleading.
All right.
That's all.
এটা extended
Well, it has been extended on the second.
Yes, Mr. Roy took a preliminary objection.
So that, my lord, in the earlier matter also, my lord has overruled that one.
Turned on here also. এখানে একটা এবারে ওটা লিখুন ওই in view of arguable questions having been raised on facts and law, comma, the appeal will be heard. The appeal is hereby admitted and shall be heard on the grounds taken in the memorandum of appeal. Yes. Now we hear Mr. Rai.
Yes.
Sir, on the injunction application, you can agree on the appeal being decided or the injunction application only? Stay application only.
Yes, my lord, as on this day, this application for stay is before me.
Only that. Very well.
Now, my lord, your lordships kindly consider how I have been removed from the office. If your lordships kindly see, my lord, the rules and regulations of the organization, my lord, that is starts at page 67. Now, my lord, kindly come to the relevant page at 71.
Yes.
May I read for you, lordship, my lord? সাধারণভাবে 3 মাসের মধ্যে অন্তত একবার পরিচালক বর্গের অধিবেশন
আহুত
হইবে। সম্পাদক এই অধিবেশন আহ্বান করিবেন, ন্যূনপক্ষে 4 সদস্যের উপস্থিতিতে অধিবেশন কার্য আরম্ভ হইবে। যে কোনো 5 জন সদস্য এক্ষেত্রে বিশেষ বিষয়ে আলোচনা করার দাবি করিয়া নির্দিষ্ট সময়ান্তে পরিচালক বর্গের সভা আহ্বানের জন্য সম্পাদককে অনুরোধ জানাইবেন। অন্যথায় পূর্বোক্ত 5 জন সভ্য নিজেরাই সভা আহ্বান করিতে পারিবেন। নেক্সট লাইনস ইজ ভেরি ইম্পর্টেন্ট, হুইচ আই এম প্লেসিং স্ট্রেস। ঐরূপ সভায় বিজ্ঞপ্তির অন্তর্ভুক্ত বিষয় ছাড়া অন্য কোনো বিষয় আলোচনা করা চলিবে না। পরিচালক বর্গের প্রত্যেক সদস্যকে 7 দিন পূর্বে সভার স্থান, সময় এবং কার্যসূচি জানাইতে হইবে। জরুরি কোনো সভা 24 ঘন্টার নোটিশে আহ্বান করা যেতে পারে। So far as the emergency meeting is concerned, that can be called by a notice not less than 24 hours. Now, kindly now come to page 83.
Your removal was with a 24-hour notice? According to them.
According to them. Now, my lord, kindly come to page 23.
83.
83, I'm sorry, my lord, 83. My lord, this notice was of, I'm sorry.
Yes, this notice.
This notice was of 16 January 2024, issued at 11:25 a.m.
Yes.
Now, my lord, kindly come to President Govindapur Shefali Samaj Seva Samiti to Molloy, that is, my lord, my client. To their client. Now, my lord, the notice was, my lord, mailed to Durga SG 1963 gmail.com. Now, my lord, this is not the correct mail. This is not the correct mail form. My lord, it is all capital.
Mail of whom?
Mail of this
Durga.
Molloy. I'm sorry, it is to Subhash. It is the Subhash Ghosh's mail form.
Who is Subhash Ghosh?
Subhash Ghosh, my lord, is the
client.
Yes, my client. 2. Plaintiff number 2.
Plaintiff number 2, yes.
Now, my lord, this is not his mail address.
His mail address does not find place here at all in this list. His actual mail address is not there in this list.
Not there. This, madam, it is all capital. Durga SG 1963. Mail address always should be in small letter, not in capital letter. Now, my lord, this is the notice that was the meeting was held and the notice was filed. What is the resolution? An emergent meeting has been invited on 16th of Govindapur such and such to discuss the agendas.
Mail address always has to be in small. I didn't know.
This is my lord, our address is not this mail address. My lord, although the mail address is, but it is in my to me.
How it has reached?
No, Mr.
These documents were supplied by Mr. Basu's client. This is not along with this stay application. This is not with me. This document was not with me. My lord, it was never served. Now, my lord, what is the agenda? Institutional management, academic development, formation of supervisory committee, annual general meeting 2023-2024. Now, my lord, miscellaneous, all members are requested to attend the meeting at 3 p.m. Now, my lord, this notice on 16 January and the meeting has been invited on 16 January. This notice was issued at 11:25. The meeting will be held at 3 p.m.
Same day.
Same day. Within 4 hours. Now, my lord, on 16th, the meeting was held according to them. An urgent meeting was held, being held on 16th at 3 p.m. The members were present. Now, my lord, this recording of this meeting was not in the resolution book. It is in the letterhead. The society has the resolution book. It is not recorded in the resolution book. It is recorded in the letterhead. Now, kindly see in presence. May I read? In presence of the following members, having the quorum of the meeting, this majority resolution is resolved that considering the irregular and poor intervention of the society members in institutional management, various activities and irregularities observed, as well as smooth management of its different endeavors, it is felt necessary to form a supervisory committee for mentioning regular institutional management and to provide proper guidance to the society management staff and students. Now, my lord, kindly come to page 86. That is on 22nd January 2024 at 9:20 p.m. 9:20 p.m. Here also the mail was in Durga, that is in capital letter. Now, my lord,
Your mail ID is the same in
but it's small letter.
lowercase.
Small letter. Now, my lord, next page, my lord, 87, the same thing.
Page 86 is a normal communication.
Yes. Now, my lord, page 88.
A show cause notice already. Page 88, yes.
My lord, nomination of chairperson of supervisory committee. All these on 16 January. When the meeting was scheduled to be held, notice was given at 11:25 and the meeting was held at 3 p.m. With reference to the majority resolution adopted in the meeting, society held on 16 January and being, this is 16 January is not typed, it is handwritten. Being interested, I, the undersigned, do hereby nominate you as chairperson of the supervisory committee for our society. Now, my lord,
who is being nominated? The defendant.
Mr. Bakibullah Mullah.
I mean, your other side.
No. He is nobody.
Achha.
Now, my lord, kindly come to at page 90. Meeting of the governing body is conducted on 6th February on the basis of the notice on 25th January at 3 p.m. Now, the secretary was not present and he was not informed.
Secretary means you.
Yes, I was not present and I was not informed. Now, my lord, resolutions, what the resolution taken, last paragraph. To show cause notices and reminders in the name of Subhash Ghosh, Secretary of Govindpur, such and such, and Mr. Subarna Ghosh, member of Govindpur, Samana, was issued. Following are the details. Then, this notice was the cash expenditure offense office expenses from such and such, which amounts to such and such rupees. Now, next page 91. First paragraph, Mr. Subhash Ghosh and Mr. Subarna Ghosh have remained silent and not showed any intention to clarify the huge expenditure of society, money in cash, office expenses. First show cause notice does not include staff salary of office. Huge amount of office expenses within 2.5 months is completely unjustified, and secretary has not taken any approval of the competent authority of such huge expenditure. No labor register has been mentioned by the office of the secretary, but labor expenses has reached to 4,41,570. After having phone numbers of cards in the name of Samaj, traveling expenses of society has reached to 3,46,999. There is no justification why cards have been hired and for which purpose. In such situation, all members of the present meeting, after threadbare discussion, came to conclusion that it is nothing but misappropriation, siphoning of society's money, that Mr. Subhash Ghosh and Subarna Ghosh has no reasonable answer of such misappropriation, siphoning. They will not be allowed to act as member of Samaj. From today onwards, all members have unanimously decided that Mr. Subhash Ghosh, secretary, and Mr. Subarna Ghosh, member, are terminated from the membership of society and also from the post of office bearer with immediate effect. So, my termination, resolution of my termination has been taken. As I have already submitted before, no notice here, the notice mentioned that they have served notice. I have not show cause, but I have already submitted before the lordship. Then no notice was issued in my proper mail. So, I was not aware about the notice. Last. The chair of the secretary of Govindpur Seva Samiti is now left vacant. To cope up with the situation, one emergent meeting have to be conducted today. I am stressing upon this. An emergent meeting have to be conducted today to fill up the vacant chair of office bearer, and for smooth running of the society, newly appointed secretary will serve all notices of termination to the terminated members and related department. Now, this notice was, this meeting was held on 6th February 2024, and the emergent meeting was held on the same day. Although the regulation says that to
24
hold an emergency, 24 hours notice should be served. But there is no notice of 24 hours here. Now, my lord, kindly come to my lord, next page, page 92. My resolution of meeting of Somiti from 5 p.m. onwards. 5 p.m. onward. My lord, on the very day. My lord, then my lord, the quorum meeting declared the permission of the president, members present signed. Now, my lord, resolution, agenda confirmation of resolution of meeting dated 6 started at 3:10. 3:10 meeting started, my lord, on 5 the resolution taken. The resolution taken
310
in
was the
meeting-
previous meeting.
Yes. Now, my lord,
Same day.
resolution taken in meeting is read out loudly before all members present in the meeting. After hearing the resolution, all members unanimously accepted the resolution, and resolution taken in the meeting on 6 at 3 p.m. is confirmed. Selection of Secretary Govindpur Samaj as the position is now vacant due to termination of Mr. Subhash Ghosh. Malay Pit proposed the name of Sofikul Alam Mandal as secretary, and Mr. Sagar Rana supported Malay Pit's proposal for selection
So
of
you say this
Sofikul Alam.
entire process was illegal. The notice was the
Yes.
proper notice was not given, not
Yes.
at your mail ID. The timeline was wrong, and everything. And but regarding this, what about urgency? Mr. Basu raised a point.
Because
After a year, you have filed
immediately
it.
after, immediately after receiving the notice of termination, Malad, which was sent ultimately, Malad, in my proper mail address. Malad, that document is not with me, but with my it was by sent by post. Now, Malad, now, Malad, this
So
is of
you
7 February 2024. That is at page 90.
Yes, but you filed the suit in March 2025, 1 year after. Where is the scope of urgency for expertise order? Because order 39 specifies that if an expertise order has to be granted, reasons have to be recorded for such urgency. No satisfaction recorded on that. You see the date of your plaintiff affidavit verification and injunction verification, March 25. And the cause of action pleaded in the plaintiff and the injunction is February 24. If it was so urgent, why wait for 1 year? For ad interim, that's a relevant
Malad,
point.
এটা তো এখানে এখানে 1 minute, 1 minute, just 1 minute. এটাতে এই এফআইআরটা তো আমাদের এখানে দিইনি, আমরা এর সম্বন্ধে বলি, আমরা বলিনি তো, বলতে পারি না। Malad, although in the plaint, Malad, it is not specifically stated
Because
that we have lost.
in effect, Mr. Rai, what has been done is that termination has been stayed means you have been reinstated, which is the final relief in the suit, in fact. We have some problem with that. You have
But
to
Malad,
satisfy us.
if I can show
Because
to your
the
lordship that
effect
the
will be that you-
termination itself is, Malad, bad.
Even if you have a
Malad,
prima facie case, the balance of convenience and inconvenience, because during this 1 year, the society has been functioning
Malad,
without
the way they have proceeded to terminate me, Malad, is
Bad.
totally bad. Totally bad because, Malad, no notice was given to me.
Bad. So
Malad,
you have
the
a
meeting which was held
you have
to
a prima facie
Malad,
case.
terminate me
You
is
have a
not
pri-
within the.
You have a prima facie case, but first of all, urgency is required in ad interim, expertise ad interim. Secondly, Mr. Rai, balance of convenience and inconvenience, because for 1 year the society is running without you. Suddenly, by this order, it has been reverted back to a date antecedent by 1 year. Not only at the time of hearing of the suit, but it's in a sense a mandatory injunction.
Malad, the
The clock
Malad,
has been turned back to 1 year, not a matter of joke.
But Malad, after this termination, Malad, there was defalcation of amount about 4 crores.
Where is that allegation?
Malad,
Nothing.
Malad, we lost an FIR. Malad, this is subsequent
Mr.
to this,
Rai,
Malad.
Mr. Rai, the order records mismanagement and all. There is no basis for that in the plaint.
Malad, kindly come to Malad, page 52. 56, I'm sorry.
56, yes. That is the allegation of mismanagement and
my lord.
There are Para 8, you have said, page 56, the last, just before para 9, the last sentence.
Therefore, the
Therefore,
mismanagement and
maladies
to the
also
to the
being
unauthorized
wasted,
persons
whatever
of
that
the
means.
property is also being wasted.
Where is the allegation before that? Of what mismanagement? Mismanagement and maladministration is restricted to your termination. So you are terminated, therefore there's a mismanagement. There's a big jump in between. Merely because you are terminated automatically does not mean that the society is being mismanaged. Supposing even if your termination was bad, if you get a relief in the suit, it will be reinstated. But where is the question of ad interim injunction after 1 year without any defalcation allegation being there? Therefore, you start with therefore. And the preceding sentences, accordingly, the plaintiff came to know that defendant 2 and 3 in collusion sent illegal notice with help of defendant president. So entire thing is centered around your termination, which is prima facie. We also feel have a strong prima facie case regarding the termination being illegal. You will get a decree in the suit and it will be reinstated probably. But ad interim ex parte ad interim after 1 year from your removal, no allegation of mismanagement. In fact, even Mr. Basu Jr. had started that this is proper, not a proper suit under 92. But there are elements, it will be too early to say that it's not.
I have no application for revocation of leave. Leave has been granted.
Leave has been granted, but that's also not conclusive. Leave has been granted means there are ingredients. And we are also not very serious on that because, Bisara, you may say that there are ingredients of too early to adjudicate.
Although that has been recorded in order number 1.
Leave grant, we are not reopening that. But we are on urgency, and this perversity in the finding in the impugn order regarding mismanagement and whatever funds being defalcated. Misappropriation. What is the question of misappropriation?
The only I can't improve so far as the FIR is concerned, my lord, because that is
It's not there on the date of the order. It was not there, Mr. Rai. We have to proceed. We have to proceed on your plain pleadings, Mr. Rai. We have to proceed on your plaint and injunction pleadings at the ad interim stage. Even on the face of your plaint and injunction pleadings, you are not entitled to get an ad interim injunction expertise without hearing them.
No, my lord, so far as my the defalcation of money by me, that has not yet been proved because, my lord, that is, because, my lord,
What's the pleading?
My lord, that has not been proved.
Any synonym of defalcation?
My defalcation. That
your defalcation, we are not bothered. You are not a default. You have not defaulted in any doing anything. You have not defalcated anything. You have not done
on
anything.
The basis of that the alleged defalcation of money by me.
We repeat,
and
Mr. Rai. We repeat that you have got a good case on termination being bad. Notice was not. I mean, requisite time was 3-4 grounds we have already noted. Those are good grounds in this suit. Not for ex parte ad interim injunction after 1 year. The trouble be taken by the revisional court when you take out an amendment application to the plaint introducing defalcation. They oppose, it's allowed, and you come up before the revisional court. Let the trouble be taken by that court. Why should we take the trouble at this point?
All advice has been given.
All advice, Mr. Roy also knows, you also know.
No, my lord has lost the jurisdiction of advising.
No, let the revisional court take that trouble. Why should we now? Because the moment we pass that order, that will be the ground for that amendment. And definitely they'll refuse and it will be granted and revision.
Now, my lord, since they have filed the application under Order 39 Rule 4, my lord, I have the opportunity.
Those parameters are different. 39(4), they have to convince the court that there was suppression of material fact. That there was actual defalcation by them, you suppress that.
Yes. And my lord,
39(4) we were not touching. We will direct the injunction application along with the 39(4) to be heard together, Mr. Rai. On the next date, we will direct those to be heard together. But that's why, Mr. Rai, The first question we put to you was that whether we are hearing the appeal or the application. You can still agree to the appeal because we will stay this order otherwise. And that will mean nothing. Rather, if you dispose of the appeal, set aside the order on the grounds, we'll give the grounds, two grounds. We are just disclosing before you. That will help you to decide whether the appeal, we are hearing the appeal or not. One is urgency. In ex parte ad interim, that's a crucial factor. And secondly, we don't find within the four corners of the plaint or the injunction any averment of misappropriation, which is one of the prime grounds of the trial court. These are the two grounds.
Misappropriation, it was against me. The allegation was against me. So far as the misappropriation of amount is
Court
concerned.
says, I find that there are as many as 29 bank accounts of the Somiti.
Yes.
Prima facie, it is evident that there are as many as 8 institutions running under the Somiti trust. Question of misappropriation and mismanagement as because involved.
Yes.
Therefore, the balance of convenience are tilting in favor
Those
of
documents are there. Those documents were there. So far as the
documents without pleadings.
With regard to the bank account and all that. So far as the,
Defalcation, there is no allegation in the plaint or the injunction application. Everything regarding your illegal
documents
removal.
was not with me because they have annexed to the stay application. So far as these
Without an order for 27, we cannot even look into those.
They are relying.
They are not
relying upon
sacrosanct.
the-
Just
relying
because they
upon
are
the
appellants,
document.
they are not sacrosanct.
No, they were relying upon this.
They also cannot rely on documents which are not part of the trial court records.
Well, these
Cannot rely on these documents also, and these documents don't prove that they have defalcated. Yeah, they have defalcated.
No, kindly see page 98 onwards. All these documents
Sir,
were annexed by
these documents are not supported by your pleadings or your averments in the injunction or the claim.
because the bank accounts were directed to be operated by on the very day. Kindly come to 96, page 96.
Obviously, if you have removed somebody else should come in.
Yes,
But this is of 8th of February 2024. And you filed your suit on March 2025. You knew on that very date, at least on the next day, that you are not being permitted to operate the bank accounts. So decide quickly, sir, whether we are deciding the stay application or the.
No way of keeping this appeal.
No use, because we can, if we dispose of the appeal, we can at least direct the 39(4) and the injunction to be heard out on the next date. It will be taken up for hearing, and within a week thereafter, it will be within a fortnight thereafter. It will be decided.
Also, kindly record subject to your kind sanction that your lordships are not entering into
the other things,
merit of the.
Those are copy paste things. On consent of learned counsel for both the parties, the appeal itself is taken up for hearing along with the application, since the issues involved in both are identical. Push up next para. Learned senior counsel appealing for the appellant contents that the impugned order of ad interim injunction was granted without any urgency being made out by the plaintiff respondents, even on the averments made in the plaint and the injunction application. Full stop. Whereas the plaintiffs plead that the cause of action for the suit arose upon the removal of the plaintiff number 2 in the month of February 2024, the suit along with the injunction application were filed only in the month of March 2025, that is 1 year after the alleged cause of action. Full stop. Next para, that apart, a cardinal premise of the impugned order, it is argued, is that there is apprehension of misappropriation and mismanagement, without there being pleading to that effect either in the plaint or in the injunction application. Full stop. Next para, as such, it is argued that the impugned order ought to be set aside. Full stop. next para, learned senior counsel appearing for the plaintiff's respondents argues that the removal of the plaintiff number 2 as the secretary of the plaintiff number 1 society was palpably unlawful and dehors the articles of the society itself. Full stop. Next para. By placing reliance on clause 3 of the said articles, comma, it is pointed out that the same stipulates that in case of a general meeting, comma, at least 7 days prior notice has to be given to the members. Full stop. Even in case of an emergency meeting, comma, at least 24 hours notice is to be given. Full stop. Next para. However, comma, in the present case, comma, as revealed from the annexures to the stay application filed by the appellants themselves in connection with the present appeal, comma, no such notice was given. Full stop. Learned senior counsel for the respondents particularly places reliance on the annexure at page 83 of the stay application, which is purportedly the printout of an email dated January 16, 2024 at 11:25 a.m., comma, fixing an emergent meeting on the self-same date, comma, thus, comma, not even leaving 24 hours between the notice and the meeting. Full stop. That apart, comma, the email ID used, the email ID of the plaintiff stroke respondent number 2 mentioned in the said email is not the actual email ID of the plaintiff number 2. Full stop. Whereas the email ID of the plaintiff number 2 is in lower cases, comma, the email ID given in the email dated January 16, 2024 is entirely in uppercase. Full stop. Next para. That apart, comma, even from the subsequent documents annexed to the stay application, comma, it is pointed out that the mandatory stipulation of 24 hours notice has been flouted. Full stop. That apart, comma, the articles of the society provide that the meetings cannot discuss agenda beyond the agenda which has been fixed previously, comma, which has been precisely done in the present case for the purpose of removal of the plaintiff number 2 as secretary without even any prior notice to the plaintiff number 2. Full stop. Next para. As a result of such illegal removal, comma, it is argued that there has been rampant mismanagement in the society, in the affairs of the society, for which an FIR had to be lodged. Full stop. Next para. However, comma, upon hearing learned counsel for the parties, comma, we find that neither the documents annexed to the stay application nor the purported FIR which has been allegedly lodged subsequently find place as a part of the records before the learned trial judge while passing the impugned order. Full stop. Next para. From the plaint as well as the injunction application before us, comma, we do not find a single whisper as to there being any misappropriation of funds by the defendants appellants, comma, which is one of the primary premises of the impugned order of injunction. Full stop. Next para. The mere apprehension of mismanagement as mentioned in the plaint, comma, without any further particulars to back up such alleged mismanagement of the affairs of the society by the defendants stroke appellants, comma, could not have justified the ex parte ad interim order of injunction. Push up. Next para. It is well settled that the tests for grant of ex parte ad interim injunction are of a higher nature in the sense that the statute mandates the court to record proper reasons as to the justification of grant of ad interim injunction on the ground of urgency if the same is passed ex parte. Full stop. we do not find any justification on the ground of urgency, full stop. Moreover, comma, the learned trial judge entirely overlooked the fact that the cause of action pleaded in the plaint and the injunction application pertains to the month of February 2024, whereas the suit and the injunction application were filed more than 1 year thereafter, comma, in the month of March 2025. Full stop. The delay itself defeats equity, and we do not find any extreme urgency to have for the ex parte ad interim injunction to have been granted without hearing the defendant stroke appellants. Full stop. That apart, comma, as held earlier, comma, since there is no foundational pleading in the plaint and the injunction application as to mismanagement or misappropriation of the funds or the affairs of the society by the defendant stroke appellants in the plaint or the injunction, comma, the learned trial judge acted in a perverse manner in relying on such purported misappropriation and mismanagement as a basis to pass the ad interim order of injunction. Full stop. Next para. As such, comma, we find that the impugned order is tainted by the above illegalities and as such ought to be set aside. Push up next para. At this juncture, comma, we are informed that at present an application filed by the defendant's appellants under Order 39, Rule 4 of the Code of Civil Procedure is pending. Full stop. The main injunction application has been fixed for hearing on 11th June, on June 11, 2025. Full stop. Next para. Although the parameters of Order 39, Rule 4 of the Code are different from an appeal against an ad interim order of injunction under Order 43 of the Code of Civil Procedure, comma, we are of the opinion that for the ends of justice, comma, the learned trial judge ought to be requested to decide the application under Order 39, Rule 4 along with the injunction application expeditiously, comma, since the issues involved in the two would be primarily the same. Full stop. Hence, comma, FMET 143 of 2025 is allowed on contest, comma, thereby setting aside the impugned order and requesting the learned trial judge to take up for hearing both the application filed by the defendant's appellants under Order 39, Rule 4 of the Code of Civil Procedure, along with the main temporary injunction application of the plaintiff's respondents on the next date fixed, that is on June 11, 2025, positively, and to dispose of the said applications within a fortnight thereafter. Push up next para. It is further made clear that the findings rendered in this order are all tentative, comma, arrived at only for the purpose of deciding an appeal from an ad interim order of injunction and shall not be binding in any manner on the learned trial judge at any further stage of the injunction application and stroke or the suit. Full stop. It will be open to the learned trial judge to decide all pending applications and the suit on their own merits without being influenced unduly in any manner by the observations made above. Full stop. Consequentially, Can 1 of 2025 is also disposed of. There will be no rise to cost.
So far as lost in relevance when my lord has set aside this order.
No, 39.4 parameters are different, you have said.
That is it. But then it is infructuous today. I think so.
Yes.
My lord, one more point, my lord, they may be restrained from making any capital expenditure because, my lord, if during this period the capital expenditure is made, my lord, then the situation will become, my lord, reversible, my lord, when the injunction application will be taken up for hearing.
There is no allegation, my lord.
Basis in your plaint and the injunction that because we'll be doing what the trial we castigated
because,
the trial
my
court
lord, as I have submitted, my lord, already 4 crores of rupees has already been, my lord, after this order, my lord, the 4 crores of rupees, my lord, without the leave of the learned district judge may be granted, my lord, that restriction may be granted because, my lord,
know what to do in your connection with your injunction application. Those are subsequent facts. So whatever in law you can do, you do. Because those are subsequent facts. We have not prevented you from doing anything before 11th June.
But while Lord Watson is signing, can you think that 39.4 is today redundant. Can think of that.
We'll add a
Force
phrase
is, dictated right
for
what you
whatever
said.
it's worth. Next. এই এটাও জাজমেন্ট ফরওয়ার্ড অ্যাপিল হয়ে গেল 33 years. অনেকদিন বাদে কোনো অ্যাপিল পাচ্ছি কোনো ডিফেক্ট নেই yes
The order dated 18th of February 2025. Number the order refusing to grant ad interim order of injunction in respect of a suit filed at the for specific performance of the contract under section 10 of the
section
10 of the specific review. The what is it called?
What is the plain? What is it?
I have annexed in the stay application.
You have not given the name of the learned trial judge in the memorandum. That was missed out by the. We'll give you liberty to do that during the course of the day. We'll take up the appeal right now.
Fine.
প্রথম লাইন একটা লিখে নাও leave is granted to the learned advocate on record for the appellant to insert the name of the learned trial judge in the preamble to the memorandum of appeal by tomorrow. Try to do it during the course of the day. Yes. Where is your plain prayer?
The stay application, but the plaint is at page.
The release shot in the yes.
Starts from page 11. The prayer is at
yes, page 17. What sort of injunction did you ask for?
Not to change the nature and character. In the meantime, the dependent number 1, which I have annexed, dependent number, dependent 2, 3, and 4 is the
yes
part of the contract.
This is an unregistered agreement for sale.
Yes, the unregistered agreement for sale. These a substantial portion of money has already been received by the dependent number 2, 3, and
Can it
4.
be looked into by the court? Unregistered and unstamped, insufficiently stamped sale deed, agreement for sale.
It is between the parties. This is
between the parties.
The agreement for sale. It's then I have to place this. Normally, so far as the agreement for sale is concerned, is there is any requirement of that has to be registered.
This agreement is for sale of a property.
Yes, that agreement for sale.
Check up section 17 of the Registration Act.
These
relevant provisions of the Stamp Act. Both registrable and stampable. I mean, with higher stamps.
The only thing is that so far as the that has been accepted by and between the parties to accept the money a substantial portion of money has been
cannot rely before a court of law.
Then I have to check.
We'll remand it to the trial court. Not remand it. We'll dismiss this appeal. No, we cannot dismiss because you have made out a because there is no reason in the order.
That is only
no reason in the order.
No reasons.
It's a bad order, undoubtedly, but we cannot remand without hearing the other side. But the question of grant of injunction is also because your agreement for sale. This is a clear-cut agreement for sale. Yes. Have you got a copy of the Registration Act? Registration Act and Parle Stamp Act. যেটা আগে পাবে Have you got a copy of the registration act? You don't.
My lord, I haven't. My lord.
Have you got a phone? Just
My lord,
find out from Indian company. Not working.
It working. Well, can it be taken up tomorrow? My lord, then I will leave.
17(1)(b). Corporate or operate to create, declare, whether in present or in future, any right at your interest for the right to any more probability. You come under 17(1)(b). And also agreement for sale is also under the article. We forget, but we'll just find out. এই শুনুন না, স্ট্যাম্প প্যাডটা আনিয়ে নেবেন যেটা ওয়েস্ট বেঙ্গল অ্যামেন্ডমেন্টে আছে। স্ট্যাম্প প্যাডটা না ওয়েস্ট বেঙ্গল অ্যামেন্ডমেন্টে আছে, শিডিউল 1 তো দেখতে পাচ্ছি। Section 33 is clear. Has to be impounded.
But that's so far as section 33, my lord, of that in respect of power of attorney.
Section 33 of Stamp Act.
Sorry, my lord, this is registration.
Registration at 17(1)(b).
17(1)(b).
17(1)(b) rated section 49.
Yes.
Clearly registrable. This cannot be relied on. Stamp Act deficit, we could still understand it could be impounded. Unregistered document you cannot rely on. Even oral agreements, you can file suits on oral agreements. But if it boils down to writing, has to be registered. Will not interfere, will say, will give our reasons, not on the grounds that will affect your injunction application and suit. Decide whether you would withdraw the appeal. Have a talk with your client. Come back tomorrow. On the prayer of the appellant, the matter is adjourned for the day.
Well, adjourned for
the day for taking instruction from your client whether you would withdraw the appeal.
2 days, my lord, it will be given.
Acha, very well. Adjourned till May 7, 2025.
Item number 34.
আমাদের বইটা আমাদের বইটা ফেরত নিয়েছে। আচ্ছা, স্ট্যাম্প প্যাক না একটা কমন ল হাউসের মধ্যে বলবেন ওয়েস্ট বেঙ্গল অ্যামেন্ডমেন্ট সহ শিডিউল IA থাকবে, এতে আই আছে, বলবেন শিডিউল IA আছে, ওয়েস্ট বেঙ্গলের অ্যামেন্ডমেন্ট সহ যেন দেয়। কমন ল হাউসের মধ্যে আছে। Yes. Yes. Sir Banerjee and Mr. Mitra on two sides.
They're very short point.
Obviously very short, it's very evident.
Yes. Lord, the point involved in
Before
this
my
case
learned
is,
friend, my lord, makes his submission, my lord, this matter came up before your lordships on 16th of April 2025. My lord, when I pointed out that, my lord, the petition before your lordship, my lord, does not contain any of the trial court papers. And my lord, the documents annexed to the petition were not before the trial court. So, my lord, your lordships wanted, my learned friend, Mr. Banerjee was not there. Now, your lordships were pleased to, my lord, make an observation that they should prepare, my lord, compilation of, my lord, the papers.
on that occasion, my lord, I confess Lord, may I, if I do not go into the papers on the basis of the plain averment, my lord, if I can satisfy your lordship that the suit is barred by limitation, ex facie.
Plaint has been annexed.
No. Plaint has not been annexed.
So I could not annex. No, I prayed before lordship to hand over the copy at the time of the hearing.
These documents were not there before the court below. No.
Documents are not there before the court below.
Then you cannot annex those to the stay application.
It is their document, not our document. We have
Their
not filed-
document. They don't know.
No, we have
No,
not
no,
filed
they
anything.
filed an application for injunction.
In that injunction application, these documents were annexed.
No. Yes. They are next. Those are here. All
কি
those,
করেছো?
huh?
Yes.
All those
দেখো
documents are
দেখো
here.
ঠিক করে বলো।
All those documents are here. We have in the injunction application or similar. We got so many bulky papers, so I could not annex. I told your lordship that 2 injunction petition and 1
No, no, in the,
volumes of the suit. 2 volumes of the injunction petition.
in the injunction application, these documents which you have annexed, if you could annex the documents, why didn't you annex the plaint and the injunction?
They relied upon
The bulk
their
must be due to the annexures.
They relied upon their documents and my lord, they disclosed some of the documents annexed to. They have disclosed, we have disclosed, and they have also disclosed in the court below.
Have you got sufficient copies for them and for both the judges? The copies of the plaint, injunction, along with annexures. This is against ad interim injunction, Mr. Banerjee.
Against the final order of injunction, on the 2 points I shall argue. Lord, first point is that the procedural impropriety.
Plaint and injunction has to be before us on the
That's
basis of which
right.
the order was passed.
That's right. Injunction is annexed to the petition for a stay. Yes, yes.
Which page?
Stay application.
Which page of the stay application?
Lord, page.
State injunction, last page.
Stay application.
Which page?
No, no. Injunction petition over there.
With the injunction petition, we are discussing the injunction, there's 2 injunction petitions here. Because these are the 2 injunction.
No, no, you said annexed to the stay application. We are asking which page.
I have not annexed those, you know, those are very bulky. 2 injunction petitions are there. So, those
Why
are-
2 injunction petitions?
First of all, 1 injunction petition was filed. Subsequent to that, another that was rejected, come before the High Court. High Court passed an order.
দাঁড়া ওটা ভাবে নয় Lord, first, Lord, may I tell you, Lordship, Lord, first injunction application was filed on 8/10/2000.
Banerjee, we have to be complete. You have to come with the complete papers, and you have to have copies for them, and as well as us, so that we can take up the appeal and the application. Because we have to look into the plaint and the injunction application and the annexures there. If you had filed written objection, then those copies also.
No,
Lord, we are having our injunction petition with annexures. With annexures. We are supplying the copy to them here and now. Lord, let him only very short point we shall argue before your lordship. That if the suit is not, first of all, my lord, 2 grounds I can take. First ground is judicial impropriety. The day when the application was filed,
Oh, you, despite opportunity, did not file the written objection at all.
the first injunction petition. With regard to first injunction, second injunction petition was filed. Second injunction petition, my lord, so cause was issued, but no to so cause notice
There
was
is only one
submitted.
appeal before us.
Yes.
One appeal.
In this appeal, in the impugned order, in the memorandum, there is an impugned order.
Both the
annexed.
petitions were disposed of in one appeal, one order.
It's recorded by the learned trial judge
Yes, lordship
that
kindly
defendant
come to
number
the
1 did
order.
not file any written objection against the said injunction petitions.
Yes, petitions.
So you did not file any written objection against either of the injunction
No,
applications.
because I could not be able to give any opportunity to file objection. The court held that that 7 days so-called notice is given in the initial order. Now, Lord, this so-called notice, Lord, was not Lord submitted. As a result, my Lord, so-called notice was not served on me.
Then their
We are holding the, my Lord, certified
pleadings
copy of the
go-
order.
then their pleadings go by non-traverse.
No, pleading will go by non-traverse. Even if pleading will go by non-traverse, if I can satisfy your lordship
On the
that
face
suit
of the
itself
plaint-
is not maintainable
Very
in terms of
Then you are
section 3,
limited to that.
I can very well argue on that only. Second argument, my lord,
Yes.
that second petition for injunction was filed, court granted a so-called notice that 7 days so-called as to why injunction will not be granted. Now, so-called requisites are not filed in the court, was not served. Only Order 39, Rule 3, A, my lord, was complied with. So no so-cause was given. Lord, therefore, injunction was disposed of against me. Lord, one is procedural impropriety, another is non-maintainability of the suit. Because why? Lord, I'm telling your lordship. If your lordship kindly come to the Lord plaint prayer. Lord, according to their case, wait down.
Don't have a copy of the plaint.
Plaint again. Plaint I first
the appeal is from the order, composite order, disposing of two applications from the first application or the second application, my lord.
So do you suggest that two appeals had to be preferred?
I thought, my lord, subject to my lord. I thought so.
Yes, Mr. Banerjee, what do you say to that?
Lord, practically on the basis of the second application, interim order was passed. And say first order, my lord, first injunction application, injunction order was passed on the basis of the second application also.
Second was passed on the basis of the first, and the first was passed on the basis of its circular.
First, only, my lord, on the basis of first injunction application, ad interim was granted.
No. This temporary injunction?
Temporary injunction on the basis of the second application, temporary injunction is granted.
So you are challenging the allowing of the second temporary injunction application, not the first.
Two petitions. One appeal will be enough, my lord. According to me, my lord, one appeal will be enough. Two appeals cannot be, because one is merged with the other. First application for injunction merged with the second application for injunction, same order.
43 Rule 1 probably.
43, yes,
R,
again the
R.
injunction.
That says
Lordship.
any order, R says
any order passed.
The order passed under Order 39 Rule
Lordship.
1.
Now, my lord, any order means the order under Order 39 Rule 1 first.
Maybe on two applications too.
Maybe two applications, maybe three applications, but Lord, orders, any orders passed under order 43, I can file one appeal.
Against each of those orders, one appeal lies.
Yes, my lord, order 43 does not permit that if order is passed, then several appeals will be filed. Therefore, maintainability of the appeal is all right.
Very well, then.
Then, my lord, the second, my lord, if your lordship kindly come to our case, the list of dates, my lord, I am placing before your lordship.
We need the plaint.
Yes, plaint. First of all, plaint, my lord. Down. Plaint again.
Mr. Banerjee, better circulate whatever copies you are relying on. Because on two occasions, this matter was adjourned before you came in.
Right, my lord.
On your prayer. And we expressed our opinion that the relevant the pleadings should be there.
Lord, may I draw your lordship kind attention. Lord, whatever bulky documents are there, we have to annex the injunction application with annexures, objections, all these things.
At least you
so that, Lord, that is why we are
so that
facing.
there is a complete.
Yes, Lord, we are.
You circulate.
But, my lord, on facts, Lord, I will not argue, my lord. I will argue on point of law only, on the basis of this, whether the injunction ought to have been granted or not.
For that also, we need to look into the application and the plaint.
Yes, that is why I am placing before your lordship.
Those have to be given to them and to us.
Yes, ওদের দিয়ে দিন আর দিতে হবে তো ওদের কাছে প্লেন থাকলে হবে দিতে হবে না
They don't know whether that is the same plaint as which you are relying on.
That's right.
Because they have lost their confidence after you have annexed documents to the stay application which are not part of the record. But your learned friend is insisting that those are part of the record.
No, Lord, it is required to be supplied to them. If I have to
We are
rely
telling that
upon.
they have lost their confidence on your client because your client annexed documents in the stay application according to them, which papers were not before the trial court. But it is being insisted that those papers were before the trial court. So if that be so, there is basic loss of faith, isn't it?
Yeah, that's right, my lord, because the point would be, the my lord, point would be, my
That's
lord.
why we say whatever document you rely on, and without the plaint or the injunction, we cannot decide this appeal. Whichever way.
Without plaint and injunction application, including their annexures, my lord, your lordship cannot decide.
And if you can't decide, also your objection if you have filed any. Oh, you did.
No, I did not file any objection.
So-
I was not given any opportunity to file objection.
Before the temporary injunction application was heard, you were not given any opportunity.
Yes, that I can satisfy. I can satisfy your lordship
Hear you on that.
from the
But then
order
only the
itself.
injunction and the plaint remains along with the annexures. Whatever documents you are citing, please circulate to them, come back tomorrow and file copies before
So
us also.
tomorrow it may not be possible. Bunch of document day after tomorrow, your lordship kindly fix it so that supplementary affidavit we can file it. Annexing the copy to them.
Need not file supplementary. You can hand over copies of the injunction application, the plaint along with all annexures. That will suffice.
On that basis, we have to go to them.
But
Lordship.
that supply should be made by tomorrow at least.
By tomorrow at least.
If you please take out photocopies and Mr. Manna
I'll
supply
do
during
it
the course
today.
of the day.
I'll do it.
Give them copies today.
Instead of tomorrow, can it be on Thursday?
We'll keep it on Thursday. We take up appeal hearing.
It will be about 3,000 copies.
3,000 pages.
Copies, this is the copy of the plaint.
3,000.
3,000, about 3,000.
What
But
is
I'm
the-
showing the volumes.
Show us.
I'm showing the volumes.
That is why it is
These are the volumes. So I could not annex in the application.
So, Mr. Mitra.
My learned friend knows very well. It is their application with all documents.
And with this,
But I
kindly
could not be allowed to annex with the.
keep it on Wednesday with this. If
Well, I
this copy-
supply the requisite copies of the application.
I'm very
But I
slow.
will have the documents xerox
Mr.
today.
Mitra, you have copies of your plaint and injunction. Why
But the whole difficult. I will
put them
tell
to
your
the
lordship.
trouble of
I will
taking
tell
out?
your lordship, the paginations possibly will not, my lord. I really do not know, my lord. At least one copy, my lord. We can get copies from there, my lord. At least we know that this
The
is
right
how-
documents have been given.
This is how. No. This is how.
Well, I'll do. Well, as your lordship directs me, I will do in course of that.
Then do.
Ajay.
I will do.
Do.
Well, I will serve it tomorrow.
Then what will you do today?
I will have the documents xerox today.
It may not be possible. এরকম ভাবে বলো না।
You do today and serve tomorrow.
জজ সাহেব বলছেন কি করবো ওনাকেও তো দিতে ওদের পেজ মিলবে না
কালকের মধ্যে দাও পরশু দিন
কালকে
রাখো।
দিয়ে দাও
No, you can take your time and we'll keep the appeal whenever you say.
থার্সডে
হ্যাঁ।
Thursday we can take up hearing matters, Mr. Manna.
নেক্সট উইক এনি ডে
Tell us the day. Give us a day. We'll keep it on that.
your lordship I can
And suitable to has to be suitable to Mr. Mitra also.
কবে দিবে?
well on Tuesday
If it suits them, Mr. Mitra. Tuesday.
either Tuesday or Wednesday as your lordship please.
12-13
Then, my lord, to be on the safer side, my lord, Wednesday, I may have some personal difficulty, my lord, on Tuesday after, my lord, 3 p.m.
Oh, then we'll keep it on 14th, Wednesday, Mr. Banerjee. What does your diary say?
1 yes my lord 14th.
At the time of hearing of the matter under Order 41 Rule 11 of the Code of Civil Procedure, comma, it is contended by learned senior counsel for the respondents that the copies of the plaint and the injunction application along with all annexures have not been made a part of the stay application before this court, comma, nor are all the papers annexed to the stay application part of the trial court records. First of next para, we are of the opinion that since the present appeal arises out of the grant of temporary injunction, comma, at least the plaint and the injunction application along with their annexures are required to be placed before the court. Full stop. Accordingly, the learned advocate on record for the appellant shall circulate copies of the plaint and the injunction application along with all annexures to the learned advocates for the respondents and file copies thereof on the next returnable date. Full stop. On the prayer of the appellant, comma, the matter is adjourned till May 14, 2025, when the appeal shall next be listed under the same heading.
Lord, may I take back the list of dates, my lord, which we have?
আমি দিয়ে দিচ্ছি থাক না জজ সাহেবের কাছে থাক
Together.
On that day.
Together, you have to take out copies of these also, Mr. Man.
Yes.
Mr. Mitra does not also know what is in the list of
Yes.
it.
এটাও দিয়ে
না
দাও।
না দেবো আমি করে রেখেছি দেবো
এটাও দিয়ে দাও।
I prepare liquid numbers of list of dates for my letter.
I am 40 pilot.
plaintiff number 6 appellate before your lordship. My lord, suit for my lord, suit for declaration of share of all the plaintiffs and my lord, partition and permanent injunction.
What have you challenged?
My lord, the ad interim
Granted.
order of injunction, my lord, refused.
Or
Holding
refused,
that-
you are the plaintiff, right?
My lord, holding that, my lord, the averments in the
Is
my lord,
Redhawal, you are appearing for the defendants.
Instruction to appear, my lord, opposite party number 10 to 12, plaintiff number 1 to 5 in the court below.
You are supporting him.
my lord, the
What about, there is no caveat?
no, my lord.
Move the word.
Then my lord, the my lord,
Then you take your seat and don't rise at all. Unless he falters somewhere. Yes.
my lord, the suit for my lord, declaration of share of all plaintiffs, my lord, partition and permanent injunction. In the suit, my lord,
Yes.
the an application for ad interim order of injunction was taken up, my lord, and my lord, the urgent basis that application was moved.
Why was
before
it
the learned-
rejected? Why was it rejected?
My lord, holding that, my lord,
Yes.
that the averment in the my lord petition
Yes.
contradictory. My lord,
Not
kindly-
contradictory. Does no allegation of any overt act on the part of the city.
My lord, they are, my lord.
Yeah,
the
alleged that they're
change-
trying to develop by engaging a promoter.
But my lord, they are doing, my
Okay.
lord, the construction randomly. They are, my
Show
lord.
us your averments on that.
My lord,
in the injunction.
my lord, page. That is, my lord, annexer B, interim
Give us the page
injunction
number.
petition. Page 49, my lord. Page 49, paragraph 13. Page 49, my lord. Paragraph 13, my lord. That on, my lord, 11th February 2025, plaintiffs requested the defendants. to
Yes, yes, we are
amicably-
admitting and granting ad interim.
My lord.
The present appeal has been preferred against an order whereby the plaintiff's prayer for ad interim injunction was refused. Full stop. Next para, the matter arises out of a suit for partition. Full stop. In the plaint as well as the written objection, as well as the injunction application filed in connection therewith, comma, the plaintiffs categorically alleged that the defendants are trying to sell and transfer the suit property to third parties by taking huge money and trying to change the nature and character of the same. Full stop. The plaintiffs have also alleged that the defendant numbers 1 to 3, comma, representing themselves as the sole owner of the property, are trying to demolish the property and thereafter to promote the same by engaging promoters by taking huge amount of money from the promoter, comma, for which purpose they are trying to make new construction of building in the suit premises. Full stop. Next para. Have you produced any title deed?
No, my lord, the it is
How
of-
do you know that you are the owner? Prima facie case?
My lord, the property is a Thika property, my lord. My lord, kindly see page. That is, my lord, page page 23, my lord.
Very
Kindly see
good.
page
The court
23.
also did not deal with that. So next para.
Page 20.
However, comma, in the impugned order, comma, the learned trial judge, comma, despite recording that the plaintiffs have alleged that the defendant numbers 1 to 3 are trying to transfer the suit property and trying to develop the property by engaging a promoter, comma, observed that the said allegations are contradictory. Full stop. Also, comma, it was recorded in the impugned order that there is no allegation of any overt act on the part of the defendants. Full stop. However, comma, prima facie, we fail to understand as to what else the plaintiffs could have averred than what has been indicated above by way of overt act on the part of the defendants. Full stop. Moreover, comma, the alleged attempts of the defendant numbers 1 to 3 to transfer the suit property cannot be construed to be contradictory with the further allegation that the defendants are trying to develop the property by engaging a promoter, comma, since there may not be any contradiction between an attempt on the part of the said defendants to transfer as well as to have the property developed. full stop. Even otherwise, comma, we find from the annexures that a prima facie case for grant of injunction was made out. Full stop. Next para. Accordingly, FMAT 123 of 2020, FMA 659 of 2025 is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. Next para. In view of a strong prima facie case for grant of injunction having made out as indicated above, comma, there shall be your prayers are allegations are only against defendant numbers 1 to 3. So your injunction prayer is also against them.
My lord, one prayer, my lord.
No, not
Study photograph, my lord.
No, we can't do. Accordingly, we grant কি বললাম কোনখানে তাহলে having been made out. We hereby grant injunction restraining the respondent numbers 1 to 3 and or their men and agents from selling, transferring, alienating and or encumbering the suit property in favor of any third party and stroke or from changing the nature and character of the suit property in any manner during pendency of the application. Full stop. The petitioner shall serve copies of the application on the respondent numbers 1 to 3, indicating that the application shall be listed for hearing on May 19, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Since no relief has been sought against the other respondents, you are appealing for 10 to
14.
Achha. So, no relief has been claimed against the other defendants stroke respondent numbers 4 to 9, comma, service of notice on the said respondents is dispensed with. Full stop. Since the respondent numbers 10 to 14, comma, who are co-plaintiffs with the present appellant in the court below have already entered appearance through their learned advocate, comma, service on the said respondents is dispensed with as well.
Grateful one.
Yes, Mr. কি ভুলেছে
36, the number will be FAT number 151, but it has wrongly been typed, and accordingly, my lord, the matter has been posted under FA number 151. It should be FAT number 151.
You are appearing in which?
FAT number 151. There, your lordship directed the matter to be appeared under the heading hearing in the monthly common list. But the
মধুসূদন কি করতে টেনেন আচ্ছা এটা অ্যাকচুয়ালটা দিতে হবে কালকে দিচ্ছি মধুসূদন এফএটা লিস্ট থেকে বার করে দিই আর এফএটিটা কালকে থাকতে বলি এখনই কারেকশন করে দিচ্ছি আর তুমি মেনশন ও আচ্ছা এটা তো লিস্টে একটা অর্ডার রেকর্ড করো since the present appeal is appearing erroneously and was not mentioned for inclusion in the list for either of the parties, comma, not directed by the court to be listed, comma, let the matter go out of the list. Full stop. Very well. Kalke eta thale to be mentioned দিয়ে দিন. This will FAT will appear as to be mentioned tomorrow. We'll correct this order and keep it on the next day for you for hearing.
37 Lordship, we are appearing for respondent KMD Lordship, led by Mr. Shotojit Talukdar, my lord. One unfortunate incident has happened, my lord. On the day before yesterday, my lord, Mr. Talukdar's mother has expired, my lord. If my lord keeps it,
depends on Ms. Agarwal.
No, that personal bereavement, my lord, certainly nobody can oppose.
Give us a date, Ms. Agarwal, when it suits.
Tell him, let him give the date when Mr. Talukdar will be
Tell
there.
us.
And fix the matter, my lord, because my client is suffering.
No, it will appear in its position because it's of 2016 appeal.
Yes. And in fact, my lord,
on 10th of June.
10th of June is
before this side of the vacation.
no.
Before this side of the vacation, my lord,
No.
he would be available after 20th. In the meantime, summer vacation.
20th. 21st we are keeping it.
Yes.
Lordship.
My lord, one more thing, my lord. My lord, I have gone through the paper book. My lord, I find, my lord, a very vital document, my lord.
Missing.
Though it was exhibit, but is missing in the paper book. Though it is there in my ken. So, my lord, I am seeking a leave to file a supplementary paper book disclosing that document.
But you have to give them copies.
I'll give them.
Good.
That letter is already on the record, my lord. By way of
Learned counsel for the appellant submits in her usual fairness that one paper.
Only one letter.
My lord, kindly keep it on 20th. Lordship. 20th he would be available.
That a vital paper, which was a part of the trial court records, has been omitted in the paper book, full stop. Accordingly, on the prayer of learned counsel for the appellant, the appellant is directed to file a short supplementary paper book incorporating such omitted document with an advance copy to the learned advocate for the respondent. On the prayer of the respondent, the matter is adjourned till May 20, 2025, when it will be listed under the same. 20th May, it will appear under the same.
20th May. Lordship.
Thank you.
For the respondent.
Yeah. Respondent. Who is for the appellant?
Appellant.
You are for the appellant. তিনটে আচ্ছা আচ্ছা
দেখি হ্যাঁ
এরপর অর্ডার শিটটাও দেবেন
bonus stamp. আমাকে এইটুখানি সারাক্ষণ বলা যাবে এটা শুধু
Which one is the appeal against dismissal of the suit?
It was a combined
4
judgment.
4 and 5 is the other counterclaim.
Allowing of counterclaim. On the last occasions,
yes,
Mr. Somen Dutt on behalf of the appellant submitted at length.
Yes,
was part heard. Now
it is marked as part heard.
It was marked as part heard.
Was cancelled. My lord was
cancel করেছিলাম কেন?
My lord was a bit annoyed with me, my lord. My lord,
Yes,
I
yes.
took an adjournment, my lord.
Right.
My lord, the
Now you are ready or now?
Yes, the supplementary copy paper book has been supplied to us. We are ready now. It was not supplied to us.
Yes, but Mr. Dattu is not there.
Mr. Dattu is coming.
Pass over then. Pass over. Next matter.
I'm to respond.
Yeah, pass over করতে হবে না, এসে গেছে। Yes. All of you are appearing in this matter?
I can.
Yes.
Plaintiff have got.
Mr. Dattu, you had argued.
Yes, I have argued. I have completed, man.
Yes, yes. Just remind us once. Just in a nutshell. You are the plaintiff.
I am the plaintiff and
Yes.
my case was I am the tenant
Yes,
in respect of area for 4 car parking spaces.
Right.
I have got the lease deed as well as rehabilitation deed.
Oh, that. Their deeds exclude the car parking portions,
Exclude the car parking
whereas your
space.
deeds got for those. Right. Priyam, take it. Yes. Yes, sir.
Yes. Now, Milord, kindly see, Milord, the plaint, Milord, from volume 1 of FA4. Milord, kindly see, Milord, what are the reliefs claimed at page 7.
Yes.
A declaration that the plaintiff is a bona fide tenant in respect of demarcated and separated portion of ground floor of the premises number 12 Bidden Road, such and such, and the defendants and their main and agents associates have no right, title, and interest to demand and or collect any amount of money from the plaintiff in any manner whatsoever. A decree for permanent injunction restraining the defendants and their associates from pulling down and or breaking the wall between the building of the plaintiff's demarcated and separated rented accommodation on the ground floor of premises.
Where are you placing this?
Yes. Now, Milord, why, Milord? If your lordship, Milord, I shall be placing, Milord, the plaint. Milord, his principal relief is suit for a declaration that he is a tenant.
Yes.
Milord, under whom nowhere stated in the plaint. Nowhere. Now, Milord, for that, Milord, if your lordship would kind enough to come to page 5. Page 5. Kindly see, Milord. The paragraph 9, paragraph 10, that the plaintiff apprehends that the defendant and their associates may take the law in their own hands by breaking the wall between the building and the plaintiff's rented accommodation, and if the plaintiff does not fulfill their illegal demands as stated above, and if the defendants take the law in their own hands and pull down the said wall and the put padlock over the separated entrance gate for the exclusive use of the plaintiff, which will amount to embarking of the right, title, and interest of the plaintiff in respect of his rented accommodation. In the circumstances, the plaintiff is entitled to a decree for declaration that the plaintiff is a bona fide tenant in respect of the demarcated and separated portion of on ground floor of such and such, so that the defendants and their associates have no right, title, and or interest to demand or collect any money from the plaintiff whatsoever. Milord, this is the vague, Milord, pleading, Milord, in the plaint. Under whom, Milord, he is claiming, Milord, tenancy right, that has not been stated.
You also argued on the last occasion it is not a premises under 2E.
Very well. Then, Milord.
No, what very well? Your argument on the last time.
Milord, I did not start at all, Milord.
Yes, you had.
তুমি বলেছিলে কি বলেছিলে?
You had.
কি বলেছিলে? Very well, I have covered that. It was not very well. Now, Milord,
are you taking that point? Not premises under say to
Milord, that is not, Milord, doctor. Because my counter claim, Milord, which is my plaint, does not proceed on that basis. Kindly now, Milord.
And if not premises under 97 Act, then TP Act would come in.
TP Act will come.
In any event, tenancy, I mean, if they claim tenancy, they can argue tenancy under whichever act.
I'll show that, Milord, that they don't have that right.
No, otherwise you have.
Yes.
We are not taking that one. So the first ground is tenancy under whom not clear.
Not claim. Now, Milord, kindly comes to, Milord, page 38 of the paper book. Now, Milord, kindly comes to, Milord, page 38.
Yes.
Now, Milord, kindly see what this is an application under Order 1, Rule 10, Sub Rule 2 of the Code of Civil Procedure, filed by the plaintiff. Kindly see, Milord, 39, whom they want to add. Kindly see, hence the prayer, hence humbly prayed that your petitioner would be graciously pleased to add the said Ashish Roy, whose particulars are given in paragraph 5 above, and to pass such an order, such other further orders as your lordship in fit and proper. Now, who is this Ashish Roy? Now, Milord, kindly see, Milord, who are the defendants and the plaintiffs in this suit. Milord, the plaintiff's wife is one of the flat owner. The defendants are other flat owners. Now, Milord, this Ashish Roy and another one was the constituted power of attorney holder of the original landowners. The original landowners, Milord, they have executed, Milord, a deed, Milord, the power of attorney, there were two power of attorneys, one registered and one unregistered. Now, my lord, in the registered power of attorney, there was no, my lord, power, my lord, to induct, my lord, tenants. There was another one executed on the same day. Now, my lord, in that, my lord, power of attorney, my lord, the one paragraph is there where the constituted power of attorney holder can induct tenant. Now, my
The
lord,
unregistered one.
Unregistered one. Now, my lord, the Ashish Roy was the developer. Ashish Roy and another one. Another person was the developer. Now, my lord, this application, my lord, the pleading in the plaint is, lordship, I have shown to your lordship that they have never claimed, my lord, the stated who is the, my lord, under whom they claim, my lord, tenancy right. In when we my lord, bring these facts in our written statement along with counterclaim, in the written statement to our counterclaim, they for the first time come and say that we claim, my lord, tenancy right under Ashish, since there was a clause in the clause in the power of attorney that Ashish can induct tenant. Now, my lord, in their written statement to our counterclaim, for the first time they have come up with this pleading. Now, my lord, if your lordship would kind enough to take up the supplementary affidavit paragraph, supplementary paper book, my lord, page 4.
Yes.
Now, my lord, kindly see the order starts dated 26th August 2011.
Yes.
Entirety need not be looked into. Kindly comes
So
to
this is, you are elaborating on the Ashish Roy point.
Ashish Roy. Now, my lord, kindly comes to page 5, ordered. That the instant petition filed by the plaintiff under Order 1, Rule 10(2), dated 29 July 2011 is dismissed on contest without cost. My lord, no challenge to that.
Yes. All right.
Now, my lord, now, my lord, kindly come. Therefore, my lord, the whom, my lord, he under whom he claims tenancy, my lord, as of today, my lord, is totally vague. Therefore, my lord, if that is
in
vague,
their Order 1, Rule 10 also, they said that Ashish Roy is their land.
Ashish Roy is there.
Para 3.
Yes. Now, my lord, if that is the, my lord, principal relief in the suit declaration, whether permanent injunction restraining us from restraining them, that they could not park 4 cars in the open space, my lord, whether that can be granted.
They are not claiming any relief against Ashish Roy as such.
Not, but
even if they
against
claim
us.
tenancy under Ashish Roy, if Ashish Roy is not a party, the cause of action of the suit is against you, that you are disturbing that car parking space. The original landlord, his landlord may not be a necessary party. So how is the dismissal of Order 1, Rule 10 or this?
No, they say, my lord, therefore, my lord,
what is the significance of your argument?
Principal prayer is for declaration of tenancy right. Against whom, may I ask myself? If he is not a party, whether court can my lord, give a declaration against someone who is not a party.
No, but
this will be, my lord, in.
Suppose I claim title in a property on the strength of purchase from a particular person. You are a third person, you are disturbing my title, you are disputing my title. I file a suit for declaration against you, who is challenging my declaration because there is a legal infringement of my right. I need not make my vendor a party to that suit, because I file a suit for declaration of title. I claim through X, but Y is disturbing me. Therefore, my cause of action is against Y, and I need not implead my vendor as a party just because I claim title through him. Here, it's a bad example, the closest I could think of. But if I claim that I am a declaration is always, there are two components of tenancy. One is that your landlord, the second is the property in respect of which. So you claim a status under Section 9 of the Code of Civil Procedure that I am a tenant in respect of a property. I assert my tenancy rights in respect of the property. Against whom? Against persons who are challenging, disputing that right. I have no claim against my landlord. So he is not claiming a declaration against his landlord. Although under his landlord, he says I am a tenant under X. But why is disturbing me? So I seek a declaration that I am a tenant, which is being disputed by Y. So why not? I mean,
Therefore, my lord, declaration in relation to the suit property.
yes, his status regarding the suit property.
Here, my lord, question, my lord, will arise whether Ashish Roy could have at all given him the tenancy. My lord, that I
Yes, that definitely arise. He has to prove his tenancy.
Tenancy, exactly.
That he has to prove. But landlord need not be a necessary party.
আচ্ছা এটা দাও দেখি now my lord kindly see my lord আমাদের আমাদের আর ওর ওয়াইফের যে কোনো একটা
So your first point was this non-joiner of landlord.
Yes.
So this order 1 rule 10 dismissal and not saying under whom they are.
On one.
All on
That
on
point,
this.
on
Very.
this.
All right. What is your second point?
Yes. Now my lord kindly comes to my lord page 8 of the my lord
the
volume
first one.
1 the schedule of the plaintiff. আগের দিনই এইটা দিয়েছিলেন
সবই তো আছে আপনার ওটা
দিয়েছিলেন
yes schedule
yes kindly see what is the my lord schedule of the plaintiff. All that one demarcated and separated portion for parking 4 cars on the ground floor of the premises number 12 Bidin Row, PS Bartola, Kolkata 7,06, having a separate entrance gate meant for the said rented accommodation only, and the said portion is butted and bounded by the following. My lord, therefore, my lord, one demarcated and separate portion. My lord, they do not clarify, my lord, what is this, my lord, the area of this, my lord, demarcated and open space where they are parking cars. My lord, whether they
the area by area you mean the measurement
because this has to be specific because by
but they give the boundaries.
No, boundaries is my lord, the entire boundary of the flat.
Oh, the entire compound.
Entire compound. No, I'm sorry, my lord. Partition wall. No, they have given. They have given. The my lord, whether my lord, when this was not my lord, whether this can be done, my lord, the on a my lord, when a carving out one portion from the my lord, the entire my lord, the building, whether my lord, this is at all possible when my lord, my submission would be this was my lord, the other flat owners had my lord in their deed got right from on this portion in their deed from the my lord, original my lord vendors of the.
But their cause of action is only in respect of this portion.
Yes.
For car parking spaces.
Yes, I'll show my lord.
And Mrs. Doctor has prima facie shown us that
common space.
Their deeds include this portion, car parking spaces, whereas your deeds exclude other portions, including car parking spaces.
They don't have a deed at all.
Our rehabilitation agreement as well as lease deed.
Those.
That I will be developing.
Those are there.
Yes. Now, my lord, kindly comes to one of the, my lord, any of the deeds, my lord, which of any of the flat owners, all my lord cyclostyle deeds, my lord, kindly comes to page 70 of supplementary paper book. Any of the. This paper book has been prepared. Clumsy হয়ে গেছে না পেপার বুকটা ওর ওয়াইফেরটা বার করতে ভলিউম 2
70
yes deed of conveyance my lord
of the supplementary Yes.
Part two. No, part one.
Supplementary also there is two parts.
Yeah, in one volume, Millard, there are two parts.
Oh, achha, yes.
Millard, this is the Millard deed of conveyance, Millard, page 70, exhibit 14.
70 of the second part.
Second part.
Yes.
Kindly see, Millard. I am why I am laying so much stress on this, Millard. I will, if your lordship want to see, Millard, our the other defendants, I will also show, Millard. This has some significance because kindly comes to Millard page 72. Millard kindly comes to who, Millard, kindly see, Millard, and in the middle Ashish Roy. Ashish Roy, he is the Millard constituted power of attorney owner and the developer of the original landowners. And Millard kindly see, and who is the purchaser? Pratima Shaha, wife of Gauranga Shaha. Gauranga Shaha is the plaintiff. Therefore, plaintiff's wife is also a flat owner. Yes. Now, Millard kindly comes to Millard page 80. The said deed continues. 87. Kindly comes to page 80, Millard, clause 13.
Yes.
Kindly see.
This is one of those which deeds? The lease deeds or
No, there's purchase deeds. Flats were purchased.
Your
no, this is Millard.
There.
There, Millard, Millard, the Gauranga
wife
of
is a
plaintiff.
Yes,
she is also a flat owner along with the defendants. Now, Millard, kindly see the purchaser's interest in the undivided portion of land.
Which clause?
13, Millard.
13. Yes.
The purchaser's interest in the undivided portion of land as more fully described in first schedule shall remain joint with the other co-owners of the building who have hereto been acquired or who may thereafter acquire right, title and interest in the said building. Now, Millard, kindly see the first schedule, which is at Millard page 82. Kindly see all that partly brick, the brick built two-storied building measuring an area of 4 kathas and partly one-storied huts occupied by the tenants measuring about 2 kathas to 12 chitaks totaling about 6 kathas and 12 chitaks situated and lying in the municipal premises number 12 bidden row such and such within such and such. Therefore, Millard, entire 12 bidden row is Millard 6 kathas and 12 chitaks, and Millard all the flat owners.
The undivided share in the land.
Land, that is the open
that
space.
Goes along with every flat.
Every flat. Yes, I wanted to show because the plaintiff's wife have also purchased that. She is also a co-share. If the defendant's Millard the right goes, her right will also go. She is also on the same footing.
Yes. She will assert the right to her husband. But you don't have husbands who also own car parking spaces.
Therefore, we all have undivided Millard.
Live in the building and the husband will park the car.
Business. She will conduct.
Business or own car, we don't know. For car parking, maybe they have 4 cars, we don't
know. No, that question was put in cross-examination. Can you tell the registration of the issue?
They will purchase.
Will purchase.
What's the difficulty?
Therefore, Millard, all the flat owners, these defendants and the wife of the Millard plaintiff has
don't harp on the wife so much. The wife may not have, the wife may lose her title, but
you see the other deeds also.
Husband's gain may be wife's loss, so there's no difficulty in that. They have an arrangement. Obviously, they are spouses.
Well, then Millard.
How does that help you?
No, I wanted to show that all the flat owners have Millard
undivided that.
On the roof as well
so
as
get out of your obsession with the wife and come to the undivided portion of the
undivided portion. Millard, may I show Millard the other deeds also?
Similar, if similar,
I'll show another one.
Why?
Very good.
Just as a matter of, we are not disbelieving you unless Mr. Dotto disbelieves you. If he points out something else, then it's otherwise. Otherwise, if you say if it's all the same in all the deeds, then it's okay.
Yes.
Undivided portion of land. So you say this undivided portion of land in first schedule, as per the description of the first schedule,
Is the in
covers the entire
building as well as the open space.
Open space. Very well.
Now,
Yes.
my lord, what is the case made out by the plaintiff? Both in the plaint and the written statement to the counterclaim. They say, they initially, in view of two power of attorneys, the Ashish Roy, who was the developer, they have initially an unregistered agreement, the term used in that is rehabilitation of tenants. Well, that is I will show that is virtually an agreement for sale. And in the in the cross-examination, he admitted the balance consideration money was not paid. I will show that to your lordship. That document, along with a subsequent unregistered sale deed, an unregistered deed of lease for 21 years was executed. That is the basis of their possession. That is the basis of their possession. This is the sum and substance of their case.
But that advance amount would be adjusted with the rent curve.
Subject to correction, that is not. I'll show to your lordship, that is not.
But the language is shown by Mr. Datta. It gives them 20 something years time to
21 years.
21 years to yes, agreement for lease for 21 years. The agreement for sale was also till 21 years. I mean, within that period, it could be done. In the interregnum, they would be tenants.
In the interregnum, they will be tenants.
So either way, they have rights.
Now, kindly appreciate whether the learned trial court would have at all taken cognizance of both these documents. Even if the first document, the agreement for rehabilitation, is not seen as an agreement for sale, then also it could not. Then I leave it to a lordship whether it could have, lordship will decide whether it could have been at all marked as exhibit because it was unstamped and unregistered. Number 2, an unregistered deed of sale. Lordship knows, in view of section 17,
unregistered as well as
unstamped. The
17(1)(b).
17(1)(b) as well as 107 of the Transfer of Property Act. Year to year, compulsorily registered.
107 is a
lease. They say it was a lease. Term is lesser.
It has to be year to year.
Year to year. This is for 21 years. Whether court could have, there are one line of judgment which says, even an unregistered agreement or unregistered lease of deed can be looked into for collateral purposes, but not
collateral.
This is their possession. They are asserting possession on the basis of these two documents.
No, but since this is not a specific performance suit, then why shouldn't you call it a collateral purpose? Because that document is being relied on not for its own worth. They're not seeking a specific performance of that, because that time has not yet come. It's being used as a circumstantial evidence to establish their position in the property.
Possession in the
So
property.
why not collateral? Collateral would be an interesting argument in this, whether it's collateral purpose or not.
Collateral, in those cases, these are.
If my marriage certificate is produced to show my age, then it's a collateral purpose. If an agreement for sale, if it was for proving my marriage, then it would be directly relevant. If an agreement for sale is sought to be specifically performed, then the agreement for sale gains center stage.
Yes.
That is the document which is required. The relief is based on that. But here the relief is not that agreement on that. That's one of the basis of their possession. So possessory title is what has been claimed, and tenancy right.
And tenancy right.
So tenancy right, that lease deed is what they're claiming.
Definitely, my lord.
So lease deed coupled with that is a collateral document. That lease deed coupled with another document which is.
But here, my lord,
Yes.
the suit has been framed, my lord, as my lord, and the claim, my lord, is on the basis of that document. Here, my lord, it's not a collateral document. That is, my lord, my argument. Whether the learned trial judge could have at all looked into it for the purpose of giving relief, because they say your eviction time to file eviction suit has not matured. Why 21 years has not passed? That is their defense in the written statement. If that be so, my lord, that unregistered.
That was the basis of their position. They're not claiming. They are not asserting rights on the basis of that. I mean, they are not asserting the rights given by that agreement.
Then, my lord, may I ask myself, my lord, who are they? They are, my lord, ranked trespassers.
There's a separate lease agreement also.
Unregistered, yes. Kindly see. Agreement for lease, my lord, it is there, my lord, in the affidavit in opposition to the Order 39 Rule 4, my lord, perhaps my.
It's there, yes. Page 7 of some document was. Yes. No, page 7 of the supplementary paperwork, part 2.
Yes. It is also there.
We are not moving from document to document because we have already looked at page 7 of part 2 of the supplementary affidavit. We are restricting ourselves to that. That's probably the agreement for lease.
Page 7 is the agreement for lease.
Page 7, yes.
Yes.
No, lease deed, Mr. Datta has an interesting argument, if we remember him correctly. Lease deed law provides that if it's not, I mean, a registered document, although otherwise required to be registered, then law constitutes it to be a monthly tenancy.
Yes.
Under the TP Act,
yes.
If the document is unregistered, then an agreement, the lease is not created by that agreement. But that coupled with handing over possession or whatever, that operates as a monthly tenancy there. So it's then not compulsorily registrable.
True. That is there. In that case, my lord, kindly comes to, my lord, the lease deed ones. Kindly comes to, my lord, the lease deed ones.
Yes.
My lord, kindly comes to, there are 3, my lord, paginations, my lord, page 10.
Yes.
Kindly see the second paragraph. And whereas the said constituted attorney,
that is what he relied on also,
in compliance of the said agreement, has put the lessee herein in possession of the said 4 car parking space at the said demarcated and undivided portion of,
divided portion, he says.
Divided portion of the premises number 12 Bidden Row, Calcutta 7,06,000, but the said lease did not lessee did not pay the balance consideration money yet. Now, my lord, kindly comes to, my lord, page 11. My lord, no schedule. No schedule. Where was the, my lord? He says the said open space. Like he could have then, my lord, whatever the schedule he has, my lord, given in the plaint, that should have been there, my lord, in the lease deed also.
No, he relies on that agreement dated 10th of August at page 9, the last paragraph. Where the description is given.
Agreement for sale. The agreement for sale, my lord, is but ultimately, my lord, he says, my lord, that has not matured.
No, not matured, but it refers to the agreement for sale.
Agreement for sale.
Coupled with this, that agreement for sale defines the property.
No, definitely, my lord, defines
and they relate back to it by saying said.
The schedule, because ultimately their ultimate, they don't say, my lord, agreement for sale. Their ultimate case is on lease deed.
Yes.
Therefore, my lord, lordship would kindly
Agreement for sale is I mean, that's why it's for collateral purpose. All the more. That is the reason we are saying that it may be a collateral purpose also. Circumstantial means collateral. Their plinth is this lease deed. Definitely. Lease deed refers to an agreement for sale and says said for car parking spaces, thereby relating back to that agreement for sale.
Yes, my lord.
So it's only for the purpose of the definition. And agreement for sale is the, what should you say, the shell.
Then, my lord, therefore, my lord, whether the point comes, whether the court, whether they can at all rely upon this, my lord, being, my lord, unregistered and unstamped. Both the documents.
All right.
At all rely upon that, because their plinth as fell from your, my lords, that is the plinth of their case. To my lord, prove that, or to show that the plinth, my lord, the court has to look into it. Whether court can at all look into it. Whether court can at all look into it. My lord, I could not find, my lord, any, my lord, I was reading, my lord, the judgment, my lord, as it was placed by my learned senior friend, my lord, judgment, my lord.
Anapi.
Nothing, my lord, does not show any light, my lord, in any of the
But then again, order 41 rule 24 is there. If materials are there, we have to decide.
My lord can, yes.
If you now delegate the parties,
no, it will be
cursed.
Now, my lord, another point which my learned senior friend, my lord, has raised, my lord, that the common space, common, my lord, which is said in our, which is stated in all the deeds, my lord, there that vacant portion is not there. That vacant space, that is not there. Therefore, they cannot say, my lord, we cannot say that you are the owners of that vacant portion. Common area and facility.
He placed your deeds also.
Yes.
Your like his wife's deed. Let us come back to that because you are so obsessed with that. Let us come back to the wife.
Supplementary paper book. Yes.
That same document.
Same document.
Says something has been excluded here.
Part 2, my lord.
Yes, part 2.
Page 70.
Let us come to the schedule there.
83, my lord. Kindly see, my lord, common area. 59. It is in my lord, contradiction with clause 13.
No, that common area.
Common area, yes. My learned friend's submission is that the open space is not included in the common area and facility.
Fourth schedule.
Third and fourth.
Third is open path. Yes, third. Except areas demarcated as open covered. That is very telltale. That clearly says that this accepts the areas demarcated as open covered space. And the document confers title on the basis of these schedules.
Yes. No.
Let us see. In the body, the schedules must have been referred to.
Yes, where clause in the clause 13, my lord, kindly see, first schedule has been referred to.
First schedule. Described in first schedule. Interest in the undivided portion as more fully described in the first schedule.
Yes.
Whereas the third schedule been referred to in the body, must have been.
That's it, third schedule. From page 78, my lord, I could not, my lord.
Second schedule referred at page para 20, page 81.
Yes.
Second schedule. Third schedule we can't find. The reference to third schedule must be there somewhere.
No, before page 78, even if it is my lord stated, my lord, it has no value.
No, after page 70. The third schedule comes out of the blue.
Even fourth also.
Fourth also. So these schedules don't have any backing in the main body. Cannot be.
because the addendum clause starts from page 78. Before that are all recitals. Because whatever a party gets in the deed is the addendum clause.
Yes, yes.
To have and to hold.
No doubt. No. The second schedule refers to the third schedule.
No.
Come to the second schedule.
Yes.
Come after together with proportionate, impartible and or undivided share or interest in land comprised in the said premises mentioned in the first schedule above, and proportionate undivided share or interest in the common area and facilities provided to the said building mentioned in the third schedule. So second schedule refers to third schedule, and second schedule has been referred to in paragraph number 20. Suppose, yes. And 20 says the purchasers agrees that the word property referred to herein above means the said self-contained flat more fully described in the second schedule. Second schedule says all that self-contained flat such and such
with proportionate
with proportionate. So the expression flat, self-contained flat, it contains second schedule and
open space.
Open space, but subject to third schedule. Second schedule itself subjects itself to third schedule.
Third schedule.
And third schedule excludes those areas already demarcated as open covered parking space. 13, 20, first relates para 13 leads to first schedule. Para 20 leads to second schedule. And second schedule
includes third schedule. So complicated.
Mathematics.
Millard, in that case, Millard, kindly, Millard sees one judgment, Millard, it cannot be done. Yeah, yeah, 59.
You are ready on this?
Yeah, yeah, 59 Supreme Court, page 24.
Yes.
Kindly comes to Millard, para 13. Okay. Para 13, Millard, kindly see, it's ends with that page, Millard, Samlal Chatterjee. Last line, last word of that. Then, Millard, kindly comes from the next paragraph. Next page, the learned judge then refers. The learned judge then refers to the clauses corresponding to the last two clauses in Exhibit B and comes to the conclusion that their effect was merely to restore the position as it was when the original partner was created, and that in consequence the purchaser was entitled to the partner as it was created in 1820. And the plaintiff was plaintiff entitled to possession of Chowkidari Chakran lands as being part of the partner. Now it is to be observed that in deciding the Chowkidari Chakran lands granted in 1899 became merged is lot fully as it was in 1820. The learned judge did not consider the effect of the clause providing for sale of those lands as a district entity under the provision of the regulation when there was a default in payment of the rent payable thereon under the deed, and that in our opinion deprives the decision of much of its value. In the result, we are unable to hold that the two clauses on which the learned judges base their conclusion are really inconsistent with the earlier clause, which support the view that the grant under Exhibit B is of a distinct partner. Nor do we agree with them that the earlier clause providing for sale of Chowkidari Chakran lands in default of the payment of Jama should be construed so as to override the latter clauses. If in fact there is a conflict between the earlier and the latter clauses, and it is not possible to give effect to all of them, then the rule of construction is well established that the earlier clause that must override the latter clause and not vice versa. In Forbes versus Jitt, Lord Renberry stated that the rule in following terms: if in a deed and the earlier clause is followed by a latter clause, which destroys altogether the obligation created by earlier clause. The latter clause is to be rejected as repugnant to the earlier clause prevails. In this clause, in this case, the two clauses cannot be reconciled, and the earlier provision in that deed prevails over the latter. Clause 13 has to prevail.
Why can't it be reconciled? It refers, one refers to the other. It's a continuous flow from 13 onwards. Just see, we are reading it for you.
Yes.
Please come to 13. 13
The
says,
purchaser and purchaser's interest in the undivided portion of land
as more fully described in first schedule, shall remain joint with the other co-owners. Now, first schedule,
entire 6 kathas.
Yes.
Land and building. Therefore, then Milord, second schedule says only the flat subject to third schedule can't be reconciled. I can understand up to Milord, clause 13 can be reconciled up to Milord schedule 1, first schedule.
No, that is there. 13 refers to schedule 1. But 20 says, what about 20? Agrees that the word
even
property,
if that be so, Milord, 13 is the previous clause.
Where is the question of not reconciling?
Kindly appreciate.
In the undivided portion of land as fully, acha, very well. But clause 19 is also there, that the purchaser shall not claim the common passage as specifically mentioned in schedule as his or her absolute property, but shall enjoy the common facilities with the other co-owners with the right to ingress and egress to such and such.
Common, this is not a common passage.
Property, here the word property is used as his or her absolute property. And property is used in the context of second schedule. Very well. It's an arguable issue, definitely. We'll have to consider this construction. We'll continue. Oh. Time flies by.
Thursday.
Let it remain in the list tomorrow, because today is a Monday and we reach the matter. We don't know what will happen tomorrow.
Yes.
You heard in part for further hearing tomorrow. এগুলো থাকবে আলাদা করে।